Case number 1, State of Hawaii versus Gerhardt, 1 CPC-25-373 for further jury trial. Counsel, can I have your appearances, please?
Good morning, Your Honor. Good morning, ladies and gentlemen. Deputy Prosecuting Attorney Joel Garner for the state. Also present is Deputy Prosecuting Attorney Franklin Don Picaro Jr.
Good morning, Mr. Garner. Good morning, Ms. Picaro.
Good morning, Judge.
Good morning, Your Honor. Good morning, ladies and gentlemen. Thomas Otake and Matha Dirks on behalf of Gerhardt Koenig, who is present.
Good morning, Mr. Otake. Good morning, Mr. Dirks. Good morning. Good morning, Dr. Koenig. Gentlemen, you can all be seated. Ladies and gentlemen of the jury, good morning to all of you. Welcome back to courtroom 15. It's good to see you. I have to admit, it was a long weekend when I started court yesterday and I walked in. When I didn't see you, I thought it was a bit odd. So it's good to see all of you here back in court. Here's the schedule for today. I've had a chance to talk about it with the attorneys. We're going to finish up the presentation of evidence this morning. We don't expect it to take very long. And then I'm going to be reading the jury instructions. The jury instructions are the law that you must follow in this case. And then we'll take a break and we'll physically reset the courtroom. When we come back from that break, from that first recess, we'll move straight into the closing arguments of the attorneys. So the prosecution will have its chance to begin with its closing argument. We'll take another break, reset the courtroom. The defense has the opportunity to present its closing argument, followed by any rebuttal argument by the state. Once the closing arguments are done, I will have the final charge to the jury, and I'm going to ask the 12 jurors that are going to deliberate in this case to go into the jury deliberation room to begin consideration of the case. I expect all of that to happen this morning. I smile a little bit. What I mean is all of that is expected to happen before lunch. Our lunch break may be a little bit later, just so we can get all of that in before you begin your deliberation. As you already know, lunch is going to be brought in for the deliberating jurors. So that's the schedule that we're looking at. Lunch maybe a little bit later than 12:30, but hopefully not too much later. So that's the schedule for today. Before we continue, does anybody need any more notebooks, any pens? I see no hands. Mr. Otake, does the defense wish to present any other evidence in this case?
Yes, Your Honor. The defense will recall Detective Thomas Inuma to the stand.
Please. You can have a seat, Detective. Detective, you are still under oath.
Okay.
Good morning, Detective.
Good morning.
Just a few follow-up questions. I'm going to keep this short, but there's a few things I wanted to ask you about. You testified last week when you were called in a case by the state and asked questions by the prosecutor. You testified about your search of Gerhardt's computer and how you went through a number of files that were seized pursuant to the search warrant, correct?
Yes.
You worked with Mr. Gardner, the prosecutor, in preparing for trial in terms of going through the computer documents and your testimony, yes?
I work with the lead detective, but as far as the exhibits, the prosecutor's office were in charge of it.
Yeah, so you worked primarily with the lead detective, but the prosecutor's office and worked with HPD to settle in on the exhibits, yes?
Yes.
Now, one of the things that the prosecutor focused on in his questioning of you and in his questioning of Gerhardt
Objection, argumentative, and beyond the scope.
Oh, let him set up the question. And please ask.
related to the files seized, one of the things you're asked about was the last access timestamp on the files. You remember testifying about that?
Yes.
And isn't it true, Detective, computer operating systems like Windows records when files were last accessed, yes?
Yes.
And then you use the Magnet Axiom software in this case to pull certain files that you're allowed to pull by the search warrant, yes?
Yes.
Axiom then reports, amongst other information, what is called the last access time for those files, yes?
Yes.
And that's the last access timestamp generated by the computer system, yes?
Yes.
Now, Detective, isn't it true computers routinely access files on their own without human action, correct?
Yes.
For example, operating system processes sometimes access files, yes?
Yes.
Search indexing functions on a computer can access files, yes?
Yes.
Antivirus or security scans can access files, yes?
Yes.
Backup or sync programs can access files, yes?
Yes.
All of those can access files. A computer can access a file. Doing those things without any human clicking on or viewing the file, correct?
Yes.
And when a computer accesses files that way, it will often update the last access time, yes?
Yes.
Even though it was not a human that accessed the file, correct?
Yes.
And you talked about your experience and the training that you've gone through to become qualified as an expert in computer forensics. Have you read literature related to computer forensics and the appropriate use of these timestamps?
Yes.
Isn't it true that there is literature that cautions computer forensic examiners from drawing too strong of an inference from the last access timestamp because of this issue related to computers accessing files instead of humans? Have you read literature that talks about that?
Yes.
Now, to be fair, the search warrant only allowed you to look at some files, some files that were accessed, yes?
Yes, just within the time frame in 32 items.
Yeah, the search terms, right?
Yes.
So you didn't have access to all of the files that may have been opened or accessed during that time period, correct?
Yes.
And that being said, you cannot rule out with certainty that some of the last accesses you discussed last week may have been caused by automated processes instead of a human, correct? You cannot rule that out with any degree of certainty. Well,
Yes, that's correct. Based on the data I received, yeah, I cannot rule it out.
Okay. Thank you, Detective. No further questions.
Mr. Garner, any cross-examination?
Yes.
Please.
Okay. Good morning, Detective.
Good morning.
Welcome back. All right. So you were asked just now about the computer opening up files on its own. Is that right?
Yes.
How does that apply to the files that you testified about last week?
So for the files to open up automatically, so there's a thing called antivirus software, right? So how that program works is there's two options, right? One is if you want to do a quick scan, which would target specific files, which is known by the company where the malware or the virus might be hiding inside the computer. And there's also another a term we use is a full scan, which the antivirus software will scan the entire computer, right? Every files. How that works is if you do a full scan, it's going to look at every individual files and it's going to create a new access time. It's going to verify that these files does not contain virus. For targeted, it's going to be looking at certain files or folders which may contain the virus, right? If it doesn't have it, then just that folder itself is going to have all the same date, time, where it was accessed. Because how the virus scan works, it's a sweeping. It might show in within the same date, the time, within milliseconds apart.
Okay. Now, based on the fact that there are multiple different dates where all these different files, the financials, the divorce documents, where all these were accessed, what does that tell you about whether this was a virus scan or a person?
Okay, so how using the Axum software, if it's a case that's involved, if it's important to last access time, the file created date time or the modified date time, what I usually do is I look at the metadata. The metadata is data about the data. So for example, for photos or videos, right, it contains data such as created date time. It also have a modified date time. It's going to also show the last access time. It's going to contain GPS location data and the make and model of the device that was used to capture it. For files, it's going to contain basically the same thing. Might not have the GPS location data, but it might contain the author's name. And as far as when I was looking at when I filtered, just by looking at the date range where it was last accessed, I noticed that all the dates and the date and time that was accessed were all different. It'll be a strong indication if all the access time were all within the same date, the same time, within milliseconds. If it shows that there was over 50 files that were accessed at the same second, then that would be a strong indicator that there was some kind of automated software that accessed all of them, and it's humanly impossible to open up 50 files within a second.
Okay, so let's focus on the files from the defendant's folder that we talked about last week about divorce. Those files were accessed between December 2024 and February 2025. Is that right?
Yes.
On at least 4 different days, correct?
Yes.
And what does that tell you about whether it's human access or antivirus software or automatic access?
Okay. So just based on the limited data that I received, it appears that it was likely a human action that caused it, because if the antivirus software went into that folder, it's going to do a sweep of all the files within that folder. It's not going to just individually pick one file for that day, come back a couple days later, look for another file, and so on.
So overall, the file access that you talked about last week, is that more consistent, or that file access that you talked about last week is more consistent than with user access than automated access, correct?
Based on the data that I had, yes.
Okay. Thank you. No further questions.
Reader.
Detective, you said based on the data that you had, and you said based on the limited data I recovered, it appears more likely to be human. But you say based on the limited data because you didn't have all the data to look at what other files may have been open at that time, correct?
Yeah, so yeah, correction. So based on the limited data, it appears that it was a human
Okay.
action, but I'm not certain because I will need the full access to the computer.
Thank you, Detective. Nothing further.
Any other questions for Detective Meany?
No, thank you.
Detective, thanks for coming back.
Okay, thank you.
Mr. Otake, does the defense wish to present any other evidence in this case?
Your Honor, at this time, the defense rests.
Thank you. Mr. Garner, does the state wish to present any rebuttal evidence in this case?
No, Your Honor.
Counsel, if I can briefly have you appear at the bench of record. I'm sorry, on record. Thank you, Counsel. So at this point in time, ladies and gentlemen, I'm going to read the jury instructions to you. Ms. McCallum is going to pass out to each of you one set of these jury instructions. So you're welcome to read along with me, but you're not required to do so. Because when you go into the jury deliberation room, each of you will have your own set of jury instructions. Mr. Short. Does anybody not have a set of jury instructions? Okay. So ladies and gentlemen, I will now instruct you on the law that you must follow in reaching your verdict. You are the judges of the facts of this case. You will decide what facts were proved by the evidence. However, you must follow these instructions even if you disagree with them. You must consider all the instructions as a whole and consider each instruction in the light of all the others. Do not single out any word, phrase, sentence, or instruction and ignore the others. No word, phrase, sentence, or instruction is more important just because it is repeated in these instructions. In the event that a statement or argument made by a lawyer contradicts or misstates these instructions, you must disregard that statement or argument and follow these instructions. You must presume the defendant is innocent of the charge against him. This presumption remains with the defendant throughout the trial of the case, unless and until the prosecution proves the defendant guilty beyond a reasonable doubt. The presumption of innocence is not a mere slogan, but an essential part of the law that is binding upon you. It places upon the prosecution the duty of proving every material element of the offense charged against the defendant beyond a reasonable doubt. You must not find the defendant guilty upon mere suspicion or upon evidence which only shows that the defendant is probably guilty. What the law requires before the defendant can be found guilty is not suspicion, not probabilities, but proof of the defendant's guilt beyond a reasonable doubt. What is a reasonable doubt? It is a doubt in your mind about the defendant's guilt, which arises from the evidence presented or from the lack of evidence, and which is based upon reason and common sense. Each of you must decide individually whether there is or is not such a doubt in your mind after careful and impartial consideration of the evidence. Be mindful, however, that a doubt which has no basis in the evidence presented, or the lack of evidence, or reasonable inferences therefrom, or a doubt which is based upon imagination, suspicion, or mere speculation or guesswork is not a reasonable doubt. What is proof beyond a reasonable doubt? If, after consideration of the evidence and the law, you have a reasonable doubt of the defendant's guilt, then the prosecution has not proved the defendant's guilt beyond a reasonable doubt, and it is your duty to find the defendant not guilty. If, after consideration of the evidence and the law, you do not have a reasonable doubt of the defendant's guilt, then the prosecution has proved the defendant's guilt beyond a reasonable doubt, and it is your duty to find the defendant guilty. You must consider only the evidence that has been presented to you in this case, and inferences drawn from the evidence which are justified by reason and common sense. The charging document is a mere formal accusation, and it is not evidence of the defendant's guilt. You must not be influenced at all because the defendant has been charged with an offense. Trial procedures are governed by rules. When a lawyer believes that the rules require it, it is their duty to raise an objection. It is my responsibility to rule on such objections. You must not consider objections made by lawyers in your deliberations. Statements or arguments made by lawyers are not evidence. You should consider their arguments to you, but you are not bound by their memory or interpretation of the evidence. If I have said or done anything that has suggested to you that I favor either side, or if any of my statements or facial expressions has seemed to indicate an opinion as to which witnesses are or are not worthy of belief, or what facts are or are not proved, or what inferences should be drawn from the evidence, I instruct you to disregard it. You must also disregard any remark I may have made unless the remark was an instruction to you. You must not be influenced by pity for the defendant or by passion or prejudice against the defendant. Both the prosecution and the defendant have a right to demand, and they do demand and expect, that you will carefully and impartially consider and weigh all of the evidence and follow these instructions, and that you will reach a just verdict. You must disregard entirely any matter which the court has ordered stricken. You may, but are not required to accept as conclusively proved any fact or event which the court has judicially noticed. You must accept as conclusively proved any fact to which the parties have stipulated. While you must consider all of the evidence in determining the facts in this case, this does not mean that you are bound to give every bit of evidence the same weight. You are the sole and exclusive judges of the effect and value of the evidence and of the credibility of the witnesses. It is your exclusive right to determine whether and to what extent a witness should be believed and to give weight to his or her testimony accordingly. In evaluating the weight and credibility of a witness's testimony, you may consider the witness's appearance and demeanor, the witness's manner of testifying, the witness's intelligence, the witness's candor or frankness or lack thereof, the witness's relation, if any, to a party, the witness's temper, feeling, or bias, if any has been shown, the witness's means and opportunity of acquiring information, the probability or improbability of the witness's testimony, the extent to which the witness is supported or contradicted by other evidence, the extent to which the witness has made contradictory statements, whether in trial or at other times, and all other circumstances surrounding the witness and bearing upon his or her credibility. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause you to discredit such testimony. In weighing the effect of inconsistencies or discrepancies, whether they occur within one witness's testimony or as between different witnesses, consider whether they concern matters of importance or only matters of unimportant detail, and whether they result from innocent error or deliberate falsehood. If you find that a witness has deliberately testified falsely to any important fact, or deliberately exaggerated or suppressed any important fact, then you may reject the testimony of that witness, except for those parts which you nevertheless believe to be true. You're not bound to decide a fact one way or another, just because more witnesses testify on one side than the other. It is testimony that has a convincing force upon you that counts, and the testimony of even a single witness, if believed, can be sufficient to prove a fact. The prosecution is not required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence, or who may appear to have some knowledge of these events, or to produce all objects or documents mentioned or suggested by the evidence. The defendant has no duty or obligation to call any witnesses or produce any evidence. The defendant in this case has testified. When a defendant testifies, his credibility is to be tested in the same manner as any other witness. The defendant has a constitutional right and the legal duty to be present throughout the trial and while other witnesses testify. You must not draw any unfavorable inference regarding the credibility of the defendant's testimony on the basis that he was present during the trial. During the trial, items are received into evidence as exhibits. These exhibits will be available for your review when you deliberate. In addition to facts which counsel have stipulated to be true, and facts which the court has taken judicial notice of, there are two types of evidence: direct evidence, such as the testimony of witnesses who assert actual knowledge of a fact, and circumstantial evidence, which permits a reasonable inference of the existence of another fact. Facts may be proved by direct evidence or circumstantial evidence, or by a combination of both. The state of mind with which a person commits an act, such as intentionally, knowingly, recklessly, or negligently, may be proved by circumstantial evidence. While witnesses may see and hear, and thus be able to give direct evidence of what a person does or fails to do, there can be no eyewitness account of the state of mind with which the acts are done or omitted. But what a person does or fails to do may or may not indicate the state of mind with which he does or refrains from doing an act. A person is not guilty of an offense unless the state proves beyond a reasonable doubt that the person acted with the required states of mind, as these instructions specify, with respect to each element of the offense. The instruction for the offense charge specifies the states of mind required to be proved. During the trial, you heard the testimony of certain witnesses who were allowed to provide opinion testimony. Training and experience may make a person qualified to provide opinion testimony in a particular field. The law allows that person to state an opinion about matters in that field. Merely because such a witness has expressed an opinion does not mean, however, that you must accept this opinion. It is up to you to decide whether to accept this testimony and how much weight to give it. You must also decide whether the witness's opinions are based on sound reasons, judgment, and information. The defendant, Gerhardt, is charged with the offense of attempted murder in the second degree. A person commits the offense of attempted murder in the second degree if he intentionally engages in conduct which, under the circumstances as he believes them to be, is a substantial step in a course of conduct intended or known to cause the death of another person. There are two material elements of the offense of attempted murder in the second degree, each of which the prosecution must prove beyond a reasonable doubt. These two elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant intentionally engaged in conduct, And two, the conduct, under the circumstances as defendant believed them to be, was a substantial step in a course of conduct intended or known to be practically certain by the defendant to cause the death of Ariel Koenig. Conduct shall not be considered a substantial step unless it is strongly corroborative of the defendant's intent to commit murder in the second degree, which is intentionally or knowingly causing the death of another person. Self-defense is a defense to the charge of attempted murder in the second degree and its included offenses. Self-defense involves consideration of two issues. First, you must determine whether the defendant did or did not use deadly force. Second, you must determine whether the force used was justified. The burden is on the prosecution to prove beyond the reasonable doubt that the force used by the defendant was not justified. If the prosecution does not meet its burden, then you must find the defendant not guilty. The first issue is, did the defendant use deadly force? Deadly force means force which the defendant uses with the intent of causing, or which he knows to create a substantial risk of causing, death or serious bodily injury. Force means any bodily impact, restraint or confinement, or the threat thereof. If you determine that the defendant used deadly force, then you are to proceed to the section of this instruction entitled Deadly Force Used. If you determine that the defendant did not use deadly force, then you are to proceed to the section in this instruction entitled Deadly Force Not Used. The determination of whether or not the defendant did or did not use deadly force must be unanimous. You must then follow the law in the applicable section to determine the second issue, which is whether the force used by the defendant was justified. Deadly force used. The use of deadly force upon or toward another person is justified if the defendant reasonably believes that deadly force is necessary to protect himself on the present occasion against death or serious bodily injury. The reasonableness of the defendant's belief that the use of protective deadly force was necessary shall be determined from the viewpoint of a reasonable person in the defendant's position under the circumstances of which the defendant was aware, or as the defendant reasonably believed them to be when the deadly force was used. The use of deadly force is not justified if the defendant, with the intent of causing death or serious bodily injury, provoked the use of force against himself in the same encounter. The use of deadly force is not justifiable if the defendant knows that he can avoid the necessity of using such force with complete safety by retreating. Deadly force not used. The use of force upon or toward another person is justified if the defendant reasonably believes that the force is immediately necessary to protect himself on the present occasion against the use of unlawful force by the other person. The reasonableness of the defendant's belief that the use of protective force was immediately necessary shall be determined from the viewpoint of a reasonable person in the defendant's position under the circumstances of which the defendant was aware, or as the defendant reasonably believed them to be. The defendant may estimate the necessity for the use of force under the circumstances as he reasonably believes them to be when the force is used without retreating. Unlawful force means force which is used without the consent of the person against whom it is directed, and the use of which would constitute an unjustifiable use of deadly force or force. A person cannot consent to the infliction of death, serious bodily injury, or substantial bodily injury. Self-defense is not available for the included offenses of assault in the second degree by recklessly causing substantial bodily injury, and assault in the third degree by recklessly or negligently causing bodily injury, if the prosecution proves that 1, the defendant was reckless in believing that he was justified in using deadly force or force against the other person, or 2, the defendant was reckless in acquiring or failing to acquire any knowledge or belief which was material to the justifiability of his use of deadly force or force against the other person. If, and only if, you unanimously find that all the elements of attempted murder in the second degree has been proven by the prosecution beyond a reasonable doubt, and you unanimously find that the defendant was not acting in self-defense, then you must consider the affirmative defense of extreme mental or emotional disturbance. Extreme mental or emotional disturbance has two elements. These two elements are, one, the defendant was, at the time he attempted to cause the death of the other person, under the influence of extreme mental or emotional disturbance. And two, there was a reasonable explanation for the extreme mental or emotional disturbance. The reasonableness of the explanation shall be determined from the viewpoint of a reasonable person in the circumstances as the defendant believed them to be. The question of the defendant's self-control, or lack of it, at the time of the offense is a significant factor in deciding whether he was under the influence of extreme mental or emotional disturbance. The defendant must prove an affirmative defense by preponderance of the evidence. This means that the defendant must prove that it is more likely than not, or more probable than not, that each element of extreme mental or emotional disturbance occurred. In determining whether the defendant has proven an affirmative defense by a preponderance of the evidence, you must consider all of the evidence that has been presented to you regardless of who presented it. If you unanimously find that the defendant has proven the elements of the affirmative defense by a preponderance of the evidence, then you must find the defendant guilty of attempted manslaughter based upon extreme mental or emotional disturbance. If you unanimously find that the defendant has not proven the elements of the affirmative defense by a preponderance of the evidence, then you must find the defendant guilty of attempted murder in the second degree. If you are unable to reach a unanimous verdict as to whether the affirmative defense has been proved or not been proved, then a verdict may not be returned on attempted murder in the second degree. If, and only if, you find the defendant not guilty of attempted murder in the second degree, or you are unable to reach a unanimous verdict as to this offense, then you must consider whether the defendant is guilty or not guilty of the included offense of attempted assault in the first degree. A person commits the offense of attempted assault in the first degree if he intentionally engages in conduct under the circumstances as he believes them to be, constitutes a substantial step in a course of conduct intended to culminate in his commission of assault in the first degree. There are two material elements of the offense of attempted assault in the first degree, each of which the prosecution must prove beyond a reasonable doubt. These two elements are, one, on or about March 24, 2025, in the city and county of Honolulu, the defendant engaged in conduct which, under the circumstances as the defendant believed them to be, was a substantial step in a course of conduct intended by the defendant to culminate in the commission of assault in the first degree. And two, the defendant engaged in such conduct intentionally. Conduct shall not be considered a substantial step unless it is strongly corroborative of the defendant's intent to commit assault in the first degree. The defendant commits the offense of assault in the first degree if he intentionally or knowingly causes serious bodily injury to Ariel Kone. If, and only if, you find the defendant not guilty of attempted assault in the first degree, or you're unable to reach a unanimous verdict as to this offense, then you must consider whether the defendant is guilty or not guilty of the included offense of assault in the second degree. This offense can be committed in one of two ways: assault in the second degree, substantial bodily injury, or assault in the second degree, dangerous instrument. As to the first alternative, a person commits the offense of assault in the second degree, substantial bodily injury, if he intentionally, knowingly, or recklessly causes substantial bodily injury to another person. There are two material elements of the offense of assault in the second degree, substantial bodily injury, each of which the prosecution must prove beyond a reasonable doubt. These two elements are, one, on or about March 24, 2025, in the city and county of Honolulu, the defendant caused substantial bodily injury to Ariel Kone. And two, the defendant did so intentionally, knowingly, or recklessly. As to the second alternative, a person commits the offense of assault in the second degree, dangerous instrument, if he intentionally or knowingly causes bodily injury to another person with the dangerous instrument. There are three material elements of the offense of assault in the second degree, dangerous instrument, each of which the prosecution must prove beyond a reasonable doubt. These three elements are: 1. On or about March 24, 2025, in the city and county of Honolulu, the defendant caused bodily injury to Ariel Koenig. And 2. The defendant did so with a dangerous instrument. And 3. The defendant acted intentionally or knowingly, as to elements 1 and 2. We are to consider each alternative of assault in the second degree separately. The fact that you may find one of the alternatives has or has not been proved beyond the reasonable doubt does not mean that you must reach the same decision with respect to the other alternative. In order to find that the offense of assault in the second degree has been proved, you must unanimously agree that the same alternative, or both of the alternatives, have been proved beyond a reasonable doubt. Proof beyond the reasonable doubt of one or both of the alternatives will result in the conviction of only one offense of assault in the second degree. If, and only if, you find a defendant not guilty of assault in the second degree, or you are unable to reach a unanimous verdict as to any of the alternatives, then you must consider whether the defendant is guilty or not guilty of the included offense of assault in the third degree. This offense can be committed in either of two ways: assault in the third degree, bodily injury, or assault in the third degree, dangerous instrument. As to the first alternative, a person commits the offense of assault in the third degree, bodily injury, if he intentionally, knowingly, or recklessly causes bodily injury to another person. There are two material elements of the offense of assault in the third degree, bodily injury, each of which the prosecution must prove beyond a reasonable doubt. These two elements are: 1. On or about March 24, 2025, in the city and county of Honolulu, the defendant caused bodily injury to Ariel Koenig. And 2. The defendant did so intentionally, knowingly, or recklessly. As to the second alternative, a person commits the offense of assault in the third degree, dangerous instrument, if he negligently causes bodily injury to another person with a dangerous instrument. There are three material elements of the offense of assault in the third degree, dangerous instrument, each of which the prosecution must prove beyond a reasonable doubt. These three elements are: 1. On or about March 24, 2025, in the city and county of Honolulu, the defendant caused bodily injury to Ariel Koenig. And 2. The defendant did so with a dangerous instrument. And 3. The defendant acted negligently, as to elements 1 and 2. The fact that you may find one of the alternatives has or has not been proved beyond a reasonable doubt does not mean that you must reach the same decision with respect to the other alternative. In order to find that the offense of assault in the third degree has been proved, you must unanimously agree that the same alternative, or both of the alternatives, has been proved beyond a reasonable doubt. Proof beyond the reasonable doubt of one or both of the alternatives will result in the conviction of only one offense of assault in the third degree. Ladies and gentlemen, I'll amend the instructions so that it reads the way I read it out loud. If and only if you find that the prosecution has proved the offense of assault in the third degree beyond a reasonable doubt, then you must also consider whether the fight or scuffle was entered into by mutual consent, whether expressly or by conduct. You must determine whether the prosecution has proven beyond a reasonable doubt that the fight or scuffle was not entered into by mutual consent. This determination must be unanimous, and it is to be indicated by answering yes or no on a special interrogatory that will be provided to you. Dangerous instrument means any weapon, device, instrument, material, or substance, whether animate or inanimate, which, in the manner it is used, or is intended to be used, is known to be capable of producing death or serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death, or which causes serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Substantial bodily injury means a major avulsion, major laceration, or major penetration of the skin, or a burn of at least second-degree severity, or bone fracture, or a serious concussion, or a tearing, rupture, or corrosive damage to the esophagus, viscera, or other internal organs. Bodily injury means physical pain, illness, or any impairment of physical condition. A person acts intentionally with respect to his conduct when it is his conscious object to engage in such conduct. A person acts intentionally with respect to attendant circumstances when he is aware of the existence of such circumstances or believes or hopes that they exist. A person acts intentionally with respect to a result of his conduct when it is his conscious object to cause such a result. A person acts knowingly with respect to his conduct when he is aware that his conduct is of that nature. A person acts knowingly with respect to attendant circumstances when he is aware that such circumstances exist. A person acts knowingly with respect to the result of his conduct when he is aware that it is practically certain that his conduct will cause such a result. A person acts recklessly with respect to his conduct when he consciously disregards the substantial and unjustifiable risk that the person's conduct is of the specified nature. A person acts recklessly with respect to attendant circumstances when he consciously disregards a substantial and unjustifiable risk that such circumstances exist. A person acts recklessly with respect to a result of his conduct when he consciously disregards a substantial and unjustifiable risk that his conduct will cause such a result. A risk is substantial and unjustifiable if, considering the nature and purpose of the person's conduct and the circumstances known to him, the disregard of the risk involves a gross deviation from the standard of conduct that a law-abiding person would observe in the same situation. A person acts negligently with respect to his conduct when he should be aware of a substantial and unjustifiable risk taken that the person's conduct is of the specified nature. A person acts negligently with respect to attendant circumstances when he should be aware of a substantial and unjustifiable risk that such circumstances exist. A person acts negligently with respect to a result of his conduct when he should be aware of a substantial and unjustifiable risk that his conduct will cause such a result. A risk is substantial and unjustifiable if the person's failure to perceive it, considering the nature and purpose of his conduct and the circumstances known to him, involves a gross deviation from the standard of care that a law-abiding person would observe in the same situation. The law allows the introduction of evidence for the purpose of showing that there is more than one path to prove an element of an offense or to disprove a defense. In order for the prosecution to prove an element of an offense or to disprove a defense, all 12 jurors must unanimously agree that the same act has been proved beyond a reasonable doubt. You must not discuss or consider the subject of penalty or punishment in your deliberations of this case. A verdict must represent the considered judgment of each juror, and in order to reach a verdict, it is necessary that each juror agree thereto. In other words, your verdict must be unanimous. Each of you must decide the case for yourself, but it is your duty to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violating your individual judgment. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest belief as to the weight or effect of evidence for the mere purpose of returning a verdict. You have been allowed to take notes during this trial. When you begin deliberations, you must follow some important rules with regard to notes. 1. Notes may be used only by you to assist in refreshing your memory of the evidence. Notes are not a substitute for your own independent memory of the evidence. 2. Keep your notes to yourself and do not share or read them to any other juror. 3. You must not give certain evidence more weight simply because it appears in your notes. Do not assume that your notes are accurate or complete. 4. Some of you may not have taken notes. If you have not taken notes, You should rely on your memory of the evidence and should not be influenced by the fact that another juror took notes. Notes are not entitled to any greater weight than the memory of each juror as to what the testimony may have been. Anytime you leave the room during deliberations, leave your notes face down on your chair. 6, if you go home overnight without reaching a verdict, your notes will be kept by the court and returned to you at the start of the next day. Your notes will not be read by anyone. 7, after you have reached a verdict, your notes will be collected and destroyed. At the start of your consideration of this case, elect one of your members as foreperson to preside over your deliberations and be your spokesperson in court. You may take such time as you feel is necessary for your deliberations. You may inform the court if you have any questions about or do not understand the court's instructions. When you reach a verdict, the foreperson is to sign and date the verdict an appropriate form for which will be given to you. When you begin your deliberations, and until you are through with your consideration of this case, or you are otherwise excused by the court, it is necessary that you remain together as a body. Court personnel will be sworn to attend you and take care of any personal problems you may have and see to your comfort. If you need to communicate with the court, send a note through the bailiff. Please do not attempt to communicate with the court except in writing. During the course of this trial, you have received all of the evidence you may consider to decide the case. You must not attempt to gather any information on your own which you think might be helpful. Do not engage in any outside reading on any matter having anything to do with this case. Do not refer to dictionaries or other outside sources. Do not visit any places mentioned in the case. Do not in any other way try to learn about the case outside the courtroom. During your recesses from deliberations, when you are released to go home in the evening, you must not discuss this case with anyone or permit anyone to discuss this case with you. You must not read or listen to news accounts about this case if there are any. You must not discuss this case with any person other than your fellow jurors. You must not reveal to the court or to any other person how the jury stands, numerically or otherwise, until you have reached a unanimous verdict and it has been received by the court. You may bring in either one of the following verdicts. 1, not guilty. Or 2, guilty as charged of attempted murder in the second degree. Or 3, guilty of attempted manslaughter based upon extreme mental or emotional disturbance. Or 4, guilty of attempted assault in the first degree. Or 5, guilty of assault in the second degree. Or 6, guilty of assault in the third degree. Your verdict must be unanimous. After a verdict has been reached and your foreperson has signed and dated the verdict form, you will notify the bailiff and court will be reconvened to receive the verdict. Okay, ladies and gentlemen, we'll take our first morning recess. You leave your notebooks on your chair along with your set of jury instructions. As I indicated, the jury instructions, these 2 pages will be amended. So 2 pages will be replaced. So the written instructions that you have will be as I read them out loud here in court. Okay, we'll take a recess. We'll take a 15-minute recess. Ms. McCallum will come get you at 10:10. When you come back in, we will continue on or start with the summation or closing arguments of the parties. All rise. Page 19 of the jury instructions. Page 19 references guilty of murder in the second degree. The court read attempted murder in the second degree. So it should be amended. Last sentence in the first paragraph, the words between of and murder, the word attempted should be inserted. Same change, last sentence of the instruction, it should be attempted murder in the second degree. That's how it's read to the court. Mr. Garner, any objections to the amendment to the instructions?
No objections.
How about you, Mr. Otake?
This is on page 19, correct?
Yes, sir. Yes, sir.
In the two places where it said murder instead of attempted.
Correct.
Yeah, no problem.
And
Thank you.
then one more change, counsel. Page 24, and I need you to take a look at not just page 24, but also page 22. I read to the jury the last paragraph that's in page 22 that is not on page 24, indicating that, again, they need to consider the alternatives separately. They must be unanimous if they're going to come back on an alternative or both alternatives, and that if they do come back on two, it results in only a singular conviction. It mirrors the language in page 2, except it's assault in the third degree. As it was read, and to the amendment, Mr. Garner?
No objection.
How about you, Mr. Otake?
No objection, thank you.
Okay, now, as the instructions are read to the jury, counsel, any objections to the instructions as a whole, other than what we've already settled on the record?
Other than our previous objections, nothing new.
None from the state.
And Mr. Garner, have you had the opportunity to review the proposed verdict forms, special interrogatory, and communication forms?
Yes.
Any objections?
No.
How about you, Mr. Otake?
No objections, I did review it.
Okay. Anything we should take up before we take our recess?
Nothing from the state.
Just that we're going to take a break after. I'd ask that I think we need to take a break after the state's closing so I can set up and also show the state my PowerPoint at that point.
That's fine.
Yeah.
I intended that anyway. I did have one more thing. I'm sorry. I'm glad I remembered it. The normal course of closing is the state, take the break, defense, okay? And then go straight into the state's rebuttal.
Correct.
If the defense is going to argue the affirmative defense of extreme or emotional disturbance, then the defendant has to rebuttal. We didn't discuss that, but that is the state. So if the defense is going to argue that, then there's a rebuttal. It'll come right after the state's rebuttal. And then I'll give the final part to the jury before I send them to deliberation. Counsel, any agreement with that?
Yes, with the understanding that should that happen, the rebuttal is limited to the EMED.
Oh, it's only on email.
Yeah.
Okay. Counsel, thank you. Court's in recess.
And off record, I'm going to now look at his PowerPoint.
All right, hello everyone. It's Alien Spaceship, and the court is on a short break. So now I'll proceed to talk about the recap about what this trial is about. So, Gerhardt Koenig, the doctor, his wife was talking to another man from his work. That's what he was doing. That's what she was doing, and it was getting. It seemed to be getting rather serious. They were texting often and a lot, and they're being kind of like flirty. So seems like it was a cheating situation, and they're allegedly going to go on a trip together. The coworker and Ariel, and he went on a hiking trail with her for her birthday, and so these are the two different stories. So either he planned to delete her by bringing her to the secluded area and attacking her with a brick. I mean, not a brick, but a rock and a syringe in his hand that he's going to try to inject her with something. The other part of it is that they were on a trail and they got into a heated discussion about the cheating situation, and he took out a, he making sure I am on. Okay, that's good. I was making sure that I could be heard. I thought my microphone wasn't on for a second. So anyway, so now back to what I was talking about. And they had like the heat of the moment. They got into a fight, and she kind of pushed him, and he did something wrong where he took a rock and smashed her in the head and like pushed her off a cliff, or she fell off a cliff, however it happened, and she was very bloodied. And he had, they got into a fight, and he was physical with her, which was wrong, and he admitted he was wrong during his examination, the time when he was on the stand. So when that happened, there was no syringe that was found, and it would be very difficult for him to go and take a syringe and fight her at the same time with it. Another factor in it is that if he wanted to delete her, he could have done it while she was sleeping or taken her out at night. So there's some doubt about if he was planning to go delete her right then and there. But overall, he was on a hiking trail. They got into a fight. It got physical. She got injured, and there was a cheating situation. He allegedly pushed her off a cliff. Yes, allegedly. Or she fell off a cliff when they were fighting, and she might have pushed him first. But of course, he was in the wrong what he did. That's the two different sides. Either it was an accidental fall off a cliff, or he pushed her. It's up to the people to decide what they think. No, she did not get deleted. She's still alive. That's why there's reasonable doubt raised about him trying to murder her, because if he wanted to murder her, he could have injected her with something in her sleep. He could have taken some chloroform and put it in her face and threw her off the cliff that way. And he may have. So that is the argument that it was a heat of passion, like they were fighting in the moment, and it escalated over a planned deletion. The other side of it is he planned to take her to a secluded area and delete her there, but it didn't work, and there's witnesses. It's up to people to decide what happened, and his testimony is very good. Some people think that it means he didn't really do it intentionally. Others think that he may have done it intentionally, but that's also an interesting watch, is his testimony on the stand. Yeah, she is not dead. No, she's still alive. But yeah, when he got on the stand, a lot of us kind of thought a little bit differently about it. Although he was still wrong what he did, of course. It was different when he got on the stand and talked about it over before he got on the stand. So it was good he took the stand. I don't know if he'll be found guilty or not, but that was very interesting to see his perspective. Yeah, he had attempted murder. I'll give you exactly what the charge is, but it was attempted murder. Attempted first-degree murder. All right, so the doctor is facing charges of second-degree attempted murder in Hawaii court. So it's second-degree attempted murder. And give you an overview. The charges stem from incident in March 24, 2025, during his hike in Palipuka trial in Oahu, where he meant to celebrate the 36th birthday of his wife, Ariel Koenig. Prosecution alleges that he tried to push his wife off a cliff, which was 1,200 feet, and tried to inject her with a syringe. The syringe was never found. Yes, right. He may get assault. Yes. Yeah, the shout to the moon pies. Potential sentence: if convicted of second-degree murder, Koenig faces mandatory sentence of life in prison without possibility of parole. Right. So, she kept on talking to the guy. There is the cheating factor going on. Although that doesn't mean someone should be pushed off a cliff or be bashed in the head or anything like that. It doesn't. What he did was extremely wrong. But it seems like it may have been a heat of passion moment where they're arguing, it escalates, and they just get into like a cat fight. There's no syringe found, but he did hide for 8 to 7 hours in the woods, in the jungle, and the police officers tackled him. He could have discarded the syringe, but the syringe wasn't found. We were kind of talking about it. It'll be difficult if he's trying to hold her down and he has a syringe in his hand, but he could have just done it while she's sleeping. That could have been a way he could have done it. Or he could have taken some chloroform, put it in her face, and she would have felt unconscious, and he could have thrown her off a cliff that way. But yeah, it's either a heat of passion, or it's not a heat of passion, and it was planned. Ah, you replicated some ice cream. Yummy. I had ice cream yesterday from an ice cream cone when I was visiting grandparents. Yes, he did very good on the stand. If he's guilty or not, he did excellent. He said he was going to off himself, which is why he went into the woods. Right. And the other thing I want to mention is, since you got the idea, Zero, Emil, his son, FaceTimed his father. His father FaceTimed him, which was the son of the guy that's on trial, and he wanted to go and delete himself. So he went into the woods, to the jungle for 8 hours, because he was going to decide to take his own life. And he felt like a really terrible person. So the self-deletion, the suicide thing, was a sign of, regretting his actions. So that's another part that I also want to mention. Thank you, Mogi. That happened. So you got the first part, then afterwards he FaceTimed his son, and then he was going to go delete himself. Zero said it still doesn't remove the fact that he had set up the thought about deleting her. It was a plan to take her on a trip to delete her. She winds her up, premeditated, even if it wasn't his OG plan. Yeah, and the thing about that is, in the case, attempted self-deletion is a crime. Yeah, in this, yes, he was wrong for trying to attack her like that, and definitely in that moment, he would be potentially causing her to die. But the thing in this case is that, did he plan to do it beforehand? And there doesn't seem to be enough evidence to show that he was planning to do it in the first place. But it was something like in the moment, right? So he's in the moment, he's triggered. Hello, Noah. Welcome to the stream. Okay. Anyway, so Moki says, son says he admitted to trying to offer. He says Emil misheard and that he said that it's what she said. It makes sense. Yeah. You know, when somebody's in a moment trying to, in the heat of passion moment, when a traumatic event happens, people can remember things incorrectly, just like people that were on the Titanic or were on the different traumatic events. They may not remember things 100% the way it happened. So the son says he admitted trying to offer, but he may have misheard his father in the heat of the moment. That's what we believe may have occurred. And yes, he would be guilty, hypothetically, of in the moment, in the heat of passion, he was angry with her, upset. And Noah says, wait, asked, did she delete email? And she did. Yes, and remember, Noah, it's good to listen to your mom and to do what she says, right? And in my view, whatever she wants for you to do, you should do what she says. And thank you for letting me know what is going on. Alright, and Joe says, bro, heat of passion doesn't remove the fact that he brought her into the woods to delete her. The only thing, in my opinion, is the fact that he might have spilled the beans and they started fighting. Well, Zero, that would be a bad tactic for him to do. Because if he wanted to delete her in the woods, he could have done it at night or injected her something while she's sleeping. They got into an argument, and it was her birthday, they were trying to celebrate. Like, people could be somewhere, and that's what I thought too in the beginning, Zero. But after seeing his testimony, that is what she did. You know, they did, right? Yes, he's guilty of, hypothetically, of assault, trying to delete her in that moment. But he was trying to premeditate it beforehand is not necessarily been proven. Yes, no, always listen to your mom. If she doesn't want you on here or on the YouTube, do what she wants you to do. Yes. Okay, and alright, if she's alive, what's her side of the story? Alright, so she hit him first as the story, and yes, she's alive. So, and if she hit him first, yes. So in the story, she hit him first, and then that's to start the altercation, but that is not good for him to hit back. Another thing that, okay, Zero, so her side of the story is that, you know, they were walking, and, wait a minute, they're coming back. I'll tell you in the text.
All jurors are back in the court. Ladies and gentlemen of the jury, the attorneys will now have their opportunity to give you their closing arguments. Keep in mind, what they say is not evidence, and you're not bound by how they see or how they remember the evidence. You should consider their arguments to you, but again, you're not bound by how they see or remember the evidence. Mr. Garner, are you ready with the state's closing argument?
Yes, Your Honor.
Please.
And for the record, the state is reserving some time for rebuttal.
Understood. Thank you.
A motive.
A beating, a confession. Ladies and gentlemen, beyond a reasonable doubt, the state has proven that on March 24th, 2025, Gerhardt Koenig tried to kill his wife, Ariel. The state has proven beyond a reasonable doubt that Gerhardt Koenig committed the offense of attempted murder in the second degree. There are two elements, as Judge read to you a couple minutes ago. Element number one, on or about March 24, 2025, that if in the city and county of Honolulu, the defendant intentionally engaged in conduct. Element number two, we'll get back to in a moment. But the conduct, starting with element one, what is the conduct? What did defendant do? First, he tried to push her. That's the first conduct the defendant did. The second, the syringe. He tried to inject her with an unknown substance. And third, the beating with the rock. That is the conduct that defendant engaged in intentionally. That is the conduct that we are here to talk about for the last several weeks and for today. The second element, that conduct, under the circumstances under which defendant believed them to be, was a substantial step in a course of conduct intended or known to be practically certain by the defendant to cause the death of Ariel Koenig. So element number one, simple, it's conduct. Element number two defines what that conduct is, what it's meant to do. And the conduct in this case was meant to kill. The intent behind each one, plan A, the push, the intent was to kill. When plan A didn't work, the defendant moved on to plan B. Plan B, inject her with the syringe, knock her out, push her off the cliff. The intent behind plan B was to kill. Plan C, when the first two plans didn't work, beat her with the rock, knock her out, drag her over, or just simply kill her outright. The intent behind every single plan was to kill Ariel. Every plan, every backup plan ends in Ariel's death. The substantial step starts with the plan. The plan's in yellow because it's not a substantial step yet, it's just a plan. Next, the hike. Again, it's in yellow because he hasn't taken that last step. That last step to show he's committed to carrying out that plan, that shows he's committed to killing Ariel. The first time you get that is with the push. When the defendant takes his hands, tells Ariel, "I'm sick of this shit," and tries to push her back off the cliff. That is the first substantial step the defendant took. That didn't work. Ariel went to the ground. Ariel protected herself. The defendant took the next substantial step. He took that syringe out and he tried to inject her. But Ariel fought back. Ariel fought back, fighting for her life, knocks the syringe away, and then the defendant moves on to plan C, his third substantial step, where he takes that rock, Exhibit 2, this rock right here, the same rock that you've all held, he takes this rock and he beats her with it again and again and again and again. Those three steps are the substantial steps the defendant took to carry out his plan to kill Ariel Koenig. Before we get any further, what is not a defense? The result of the defendant's conduct. The severity of Ariel's injuries, you'll hear many times trying to minimize them. That is not a defense. The law treats somebody the same, whether they're successful or not. The law treats you the same no matter how good you are at executing that plan, no matter how good you are at actually succeeding in killing somebody. The law treats you the same. As an example, somebody who tries to shoot somebody, who points a gun and tries to end a life, but misses, they've committed attempted murder the same way the defendant committed, in a similar way, in a similar idea as the way defendant did it in this case. You cannot look only at the results to determine intent. You have to look at everything together And when you look at everything, it shows one clear answer beyond a reasonable doubt, and that's that the defendant intended to kill her. Let's review how we got there. First, we have Ariel's testimony, and she testified in 3 different areas. First, Ariel told you what happened on the Palipuka Trail on March 24th, 2025. She told you what happened when she went up the trail. She told you how she was afraid, how she was nervous about the heights. She told you how the defendant reacted. She told you what happened when she met up with the defendant later. That he pushed her, that she went to the ground, that he took the syringe, that she fought back, and then ultimately he took that rock, this same rock, and hit her in the head again and again. Then Ariel told you what happened leading up to that day. She told you about their marital issues. She told you about her messages with Jeffrey Miller. She told you all of that. Embarrassing as it may be, she put it all out there. And then Ariel told you about her treatment, her medical treatment, her recovery. She showed you the scars that she carries to this day. She showed you the scars on her head where she will never grow hair again. And everything that Ariel said is corroborated. These are the credibility factors. These are listed in your instructions that you should be considering for every witness who testified. And I'm not going to go through all of them right now, but there's a couple that are relevant for Ariel here. First, appearance, demeanor, intelligence, candor, frankness. Ariel testified in a straightforward, coherent manner. She testified clearly. There were no histrionics, barely any tears. It was straightforward. This happened, then this happened, then this happened. It was not over-dramatized. It was not over-exaggerated. It was straightforward and simple and coherent. She was open to cross-examination. When the answer was yes, she said, yes, sir. When the answer was no, she said, no, sir. And when she didn't know, she said she didn't know. But the last factor is the most important here. The extent to which Ariel's testimony is supported by other evidence. What this means, simply, is corroboration. What level of corroboration is there? There is a lot. Ariel is corroborated by the physical evidence, the scene and location, the rock, the blood evidence, the injuries, the medical supplies. Ariel is corroborated by the digital forensics. What was going on the defendant's computer corroborates what Ariel said. Ariel is corroborated by the other witnesses, by their sworn testimony, by Emil Koenig. Ariel is corroborated by Amanda Morris. She's corroborated by Sarah Buxbaum. She's corroborated by HPD. And in the most important ways, she's even corroborated by what the defendant told Emil. You've seen the photos of the scene. Ariel's testimony is corroborated. There's the cliff. It's right there. There's the bloody, the blood pool in the bush where the defendant was on top of her, where the defendant was hitting her. The physical evidence of the scene, the blood, the crushed plants, the location of this, so close to the cliff edge, all corroborates Ariel. The physical evidence, the rock, corroborates Ariel. You've held the rock. You've seen it. You know how much it weighs. You know how sharp it can be on the sides. You've seen the photos of Ariel's blood and Ariel's hair on that rock. The rock corroborates what Ariel said. The DNA evidence. The DNA evidence shows two things very clearly. One, every single sample that was positive for human blood had a likelihood ratio of over 1 trillion for Ariel Koenig. Every single one. The blood on the rock, the blood on the samples from the trail, the blood all over defendant's shirt and shorts. Every single one had a likelihood ratio of over 1 trillion for Ariel. Reason and common sense tells you all of that blood is Ariel Koenig's, not the defendant's. Second, Ariel Koenig's DNA was on both sides of the rock. And think back. Think back to how Ariel demonstrated what she did. She held up her hand. She held up her hand trying to block the defendant. She suffered defensive injuries from it on her fingers, on her thumb, and that's how her DNA is on that rock. Because she touched it. Her touch DNA is on the rock because she touched that rock to try and stop the defendant. The search warrant of defendant's work bag on Maui corroborates Ariel's statement. It shows clearly, conclusively, that defendant had actual possession. Not as some sort of theoretical, oh, he's a doctor, he can get this stuff. No, he had actual possession of syringes, he had actual possession of vials, he had actual possession of drugs that can kill. This isn't some, he could have gotten them, he had them. This corroborates Ariel's testimony. And more importantly, these drugs weren't stored in a controlled environment. They were stored in his home, where he had access. He could take them, didn't have to log them or anything, just remove them from his home and do whatever he wanted with them. This corroborates Ariel as well. Lastly, Ariel is corroborated by her injuries. The physical evidence of Ariel's injuries corroborates exactly what she said. Think of the injuries to the top of her head. The stellate laceration. Dr. Grosjean told you there was debris throughout the entire injury. There were rocks. The defendant swung this rock so hard that pieces of rock broke off into Ariel's scalp. There was dirt throughout the entire laceration. And the middle of Ariel's scalp, he described as macerated or crushed. Went all the way down to the bone. You've seen the photo of Ariel from the front. You've seen what's missing from her head. You've seen that there is a chunk of her scalp that is gone. It's right there in that photo. And you've seen that she didn't just have scalp injuries. She had injuries above her eye. She had injuries below her eye. She had injuries to her hand, not even to just her thumb. Her thumb was only where there was a break. But she had injuries to 3 of her fingers. Her thumb, her index, and her middle finger. Ariel's testimony is corroborated by the physical evidence in this case. Ariel's also corroborated by the digital forensics, the digital evidence. The digital evidence tells you what defendant was thinking. What he was thinking from December 2024 to March 2025. It shows you that, first of all, it confirms the motive. It confirms the strong motive defendant had to kill because he was looking up infidelity. He was looking up Ariel's financials. He was looking up his prior divorce. He was going into Ariel's hard drive to look up documents on her computer or from her computer about divorce. He even went to the point where he was buying a spy device to spy on Ariel. This shows what was going on in defendant's mind. It wasn't some simple research. It wasn't taxes. It wasn't self-help. It was obsession. It was an obsession with Ariel. It was an obsession with infidelity. It was an obsession with going over those financials, and it was a plan for divorce. The second thing that the digital forensics shows, most importantly, it shows defendant's familiarity with that hike. It shows you what the defendant looked at before deciding the Polipuka Trail is the hike that he should be taking Ariel on. It showed the defendant this picture right here. It showed that the defendant was only interested in difficult hikes. Easy hikes were not for him. The defendant wanted difficult hikes, steep trails, big drops, narrow trails. This is where the defendant wanted to take Ariel. This trail, about a foot wide, somewhere around there. One push. One push is all it would take on this trail. Nothing for her to grab onto. One push, and it's a tragic accident. That is what the defendant was researching. He knew that this trail was not popular from his research. He knew that 99% of the people wouldn't be going on this trail. And he knew that this is where he could execute his plan. And he didn't share this with Ariel. He didn't share this website with her, so she could make that informed decision before she went on that hike with him. She had no idea what kind of trail she was getting into that day. Lastly, Ariel's test is corroborated by the other witnesses. Ariel is corroborated by Amanda Morris. Amanda Morris, the first person on the scene. Amanda told you the sequence of events. 3 things. First, she heard a woman's voice screaming, "Help! Help me!" And she gets up the trail because she thinks somebody's fallen off. She knows it's dangerous. She thinks somebody's fallen. And she sees the defendant over Ariel. Amanda sees the defendant over Ariel. She sees the defendant with this rock in his hand, and she sees the defendant hit her. And when she sees that, Ariel cries, "Help, he's trying to kill me." And Amanda sees how the defendant responds. How the defendant responds is nothing. He just looks at her. Ariel's also corroborated by Sarah Buxbaum, the second woman on the scene, the second hiker who intervened. Sarah came in behind Amanda. She saw the defendant standing over Ariel. She saw the defendant standing with that rock. And most importantly, Sarah looked the defendant in the eye. Sarah made eye contact with the defendant and told you how that made her feel. It made her feel unsettled. It made her feel so afraid for herself and her safety when she was looking at the defendant in the eye. It made Sarah feel so unsafe that she and Amanda went back down the trail before they called 911 because they realized this was a dangerous situation for them. They realized, after looking in his eyes, what could happen to them. And they took those steps after seeing what was in the defendant's eyes. After seeing that look, they took steps to protect themselves. Listen to Sarah's voice on that 911 call. It's Exhibit 3. You'll have it. Listen to her voice, and you can hear what she's thinking about. You can hear the worry in her voice. You can hear that she's afraid for her own safety after she's seen the defendant. It's all there. And you may hear argument today, or have thought, maybe you thought to yourself, well, Amanda and Sarah only saw the end. The evidence shows that Amanda and Sarah didn't see the end of the incident. They caused the end of the incident. Because when they showed up, that is the only thing that stopped the defendant. Ariel screaming for help didn't stop the defendant. Ariel fighting back for her life didn't stop the defendant. The only thing that stopped the defendant, the only thing that was enough for him to stop, is 2 eyewitnesses coming up on the scene and seeing him beat her with that rock. The only thing that got him to stop was being caught red-handed. The responding officers, Corporal Wu, Corporal Chun, they corroborate Ariel as well. They showed you the hike. You saw the hike on their body cam. You saw their struggles with trying to get up the hike. They showed you the scene. Once more, right there in the foreground of this photo, that's where this happened. That's where the beating with the rock happened. And right there, just a couple feet away, that's where the defendant tried to push her. They showed you Ariel's condition. Ariel's condition immediately after the defendant did this. They showed you that. They showed you the closest thing to what the defendant last saw Ariel as. And they even caught it on their body cam. They even caught Ariel's condition as she states her name.
Ariel Connick. Arielle. Birthday is March 24th, 1989.
You heard Ariel testify for hours. But also, you heard in this video her slurred voice, her heavy breathing, her condition after the defendant beat her with that rock. She was not okay. The manhunt. The manhunt corroborates Ariel as well. It took 3 different agencies, HPD, DLNR's DoCare, HFD, several different units from them, SED, SSD, a canine unit, the major events unit to search with drones. It took 2 drones, 1 helicopter, and after 8 hours, or almost 8 hours, they were still not able to find the defendant. And that tells you one incredibly important thing. The defendant did not want to be found. The arrest corroborates Ariel just as much. Officers Nicola, Koki, and Borges approached Ariel in their vehicle. Officer Nicola testified he got within an arm's reach of of the defendant before he jumped out the car.
Objection, misstates his testimony.
He got within an arm's length, or close to an arm's length, before he got out that car and tried to apprehend the defendant. He identified himself as police. And how did the defendant respond? The defendant tried to flee into the woods. It took a total of 835 pounds of HPD officers to subdue the defendant. That's how much he was resisting. He knew they were police. They identified themselves as police. And as Officer Nicola testified, the defendant, in his attempt to get away, fell on his face, and then Officer Nicola fell on top of him. That's why you see the grass on the defendant's head. That's why you see the dirt on the left side of the defendant's face, because that's where he hit the ground. That's where he hit the ground while he was being arrested. And the defendant's own actions, finally, also corroborate what Ariel told you. Defendant's actions corroborate Ariel's testimony. First, he fled the scene. Second, he collected the evidence from the scene. He collected Ariel's phone. He collected Ariel's purse. And he collected those syringes. He took all those items from the scene and he disposed of them. Ariel's mom still tried to ping her phone, and it was up at the poly hours later, but they could never find it. And think back, where the police, where DoCare couldn't search. They couldn't search the bottom of the cliff. They couldn't get down that way. They searched the whole mountainside, couldn't find it, but the bottom of that cliff that's several hundred feet tall, that's where they couldn't search. Defendant confessed. Defendant called Emil just minutes after the incident and told Emil, "I tried to kill Ariel, but she got away." And lastly, the defendant hid in the woods for almost 8 hours. These actions that the defendant took corroborate what Ariel told you. They make sense. That being said, the defendant in this case has testified. And you need to judge his testimony the exact same way that you judge anybody's. At the beginning of this trial, you heard a theme, some alliteration with a theme, unwilling or unfaithful, unwilling, untrue. But ladies and gentlemen, after listening to the defendant's testimony, you only need one word to summarize it. One word. Unbelievable. The defendant's story. She started an argument. The defendant's story is that somehow Ariel, on her birthday, on an unfamiliar hike next to a massive cliff, decided to start an argument. Does that make sense to you? No. Ariel decided somehow to start an argument about she said she wanted to go back and continue to work with Jeff Miller. She wants to travel with Jeff Miller. Does that make sense that Ariel would bring this up on that cliffside? No. It contradicts common sense. It even contradicts the defendant's own testimony where he told you they don't talk about this outside of counseling. The defendant told you that. And that's what worked for them. And somehow Ariel's bringing it up, ruining her birthday on a hike. Ladies and gentlemen, it's unbelievable. The next part. The defendant's story, she pushed me. The defendant says he felt a hard push from behind, that he was looking out over the cliff. He barely holds himself on. He turns around, and Ariel's already 5 to 10 feet away. Ladies and gentlemen, unbelievable. If Ariel was trying to push him off that cliff, she wouldn't be that far away. She would have been right behind him, trying to push him again. Defendant's story, she pulled me down on top of her. Think about how that makes sense. Defendant's story is that then he approached Ariel. That he grabbed her arms. And Ariel somehow responded by pulling him down on top of her and not letting him go. Defendant's bigger than her. Defendant's stronger than her. Ask yourself, what person would hold a bigger, stronger person on top of them as an act of aggression? It doesn't make sense. It's unbelievable. Defendant's story, she hit me first. Somehow while Ariel's sitting down, or while Ariel's underneath him, while he's in the position of power, while he's on top of her, the story is that Ariel held him down so he couldn't escape, grabbed his genitals, wrapped her legs around him, and then she picks up a rock and hits him in the face. And as the defendant told you, he said, she hit me one time really good, and that she keeps swinging. The same rock that the defendant used to beat Ariel? Really? The same rock that defendant has told you he only used 2 times, that he only hit her twice with. Ladies and gentlemen, it's unbelievable. The same rock, no. You can tell it's different injuries. This is the photo of the defendant immediately after his arrest. This is the photo of the defendant almost 8 hours after the incident up on the trail, after the defendant tried to kill Ariel. Yes, there's a small dark spot on his cheek. Is it a bruise? Is it dirt? I don't know. This is Ariel. The idea that this same rock caused these different injuries is unbelievable, ladies and gentlemen. The idea that Ariel could hit him really good, and that's it, is unbelievable. This is the defendant at the hospital that night, and this is Ariel at the hospital on the same day. Again, minor bruise, major laceration. The idea that these injuries were caused by the same rock, completely unbelievable. You can only see that by looking at the next day. Look at the defendant 1 day later. There's nothing. There's no more. Ariel's got her head wrapped up. She's still got these injuries on her eye. The defendant's story is unbelievable. And lastly, the defendant told you that he wanted to turn himself in. That's what he was doing when he left the trail. Sunset was coming soon. The sun was getting low. But instead of doing the logical thing and walking down the trail where he knew the police would be, the defendant decides he has to come out of the forest onto the road. The defendant doesn't go back to the trailhead. He doesn't put his SIM card back in his phone. He doesn't turn his phone on because he's not trying to surrender himself. He's not trying to turn himself in. He's trying to escape. And that's why he ran when the police apprehended him. That's why he resisted. The defendant's story, unbelievable. The defendant's story, unlike Ariel's, where Ariel is corroborated, the defendant's story is filled with contradictions. The defendant is contradicted by Amanda and Sarah. Somehow, Ariel finally let go of his private parts, and then he just stands there and looks? He's not on the ground writhing in pain? Does that make sense? He says that she held on so hard that he couldn't escape. Does it make sense that afterwards he would just stand there and stare? No. Defendant is contradicted by the physical evidence. He's contradicted by the fact that there's no blood of his up there. There's no evidence of injuries that support what defendant says happened. He's even contradicted by his own hired doctor. The defendant told you he hit her twice. No more. But even his own doctor said 2 to 3 hits to the scalp. Hits to the face. Hits to the fingers. So even the defendant's own witness shows that he hit her more than twice. He hit her, add them all up, 4, 5, 6, could be any of those times. He hit her again and again and again and again. And he only told you 2 times. Ladies and gentlemen, it's unbelievable. He told you he removed his SIM card with a paper clip. Well, State 72 through States 86, that's all the photos. That's all the contents of defendant's backpack. Where is that paper clip? He could have just as easily used that syringe. Open his SIM card, dispose of the syringe. Hiding evidence 2 ways at once. The substantial step again. He made the plan. He made the plan to go hiking that day. He didn't share with Ariel what hike they were going on. He didn't share the details of that hike with Ariel. He didn't share the dangers of that hike with Ariel because his plan was to push her off that cliff. So they start the hike, and Ariel deviates from the plan. Ariel doesn't go up to that section from the photo, the super narrow section with no trees. Ariel doesn't want to go up there. So the defendant improvises. The defendant takes a different cliff. The defendant sees his last chance when they take this selfie, his last chance before they get to that lower part of the trail, and he takes it. He takes that chance to try and push Ariel off. He takes that chance. He makes that substantial step. And plan A, the push, doesn't work. Ariel falls to the ground. He can't push her off anymore. So he takes that next step. He pulls out the syringe. Plan B. And he tries to stab her with it. Plan C, when that doesn't work, he takes that rock and he hits her well over 2 times. He hits her again. He hits her again. It doesn't matter that she's blocking. It doesn't matter that she's screaming. The only thing that gets him to stop is these 2 women who walk up. That's it. You have gotten instructions about self-defense. It should be clear. The defendant was using deadly force in this case. This rock is known to the defendant to cause death or serious bodily injury. You don't need to be a doctor, although he is. And he's actually treated patients who've had rocks fall on them. So the defendant is well aware of the damage that he was doing. He's more than aware because it was his intent. It was his intent to cause that damage. It was his intent to cause death. So yes, it is clear the defendant was using deadly force. And because of that, self-defense doesn't apply. Or self-defense does apply, but defendant cannot claim it because he was the initial aggressor. He was the one who started the physical altercation. He was the one who used deadly force. And lastly, he had a duty to retreat. When using deadly force, before you use that deadly force, the law states you have a duty to retreat. And the defendant didn't do that.
Incomplete statement on the law.
Objection overruled. Ladies and gentlemen, the court instructed you on what the applicable law is. You need to follow the court's instructions as read out to you and as it's provided in the jury instructions that you have.
The defendant did not follow the law. The defendant attacked her. Self-defense is not applicable. The the state has disproven it beyond reasonable doubt because the defendant was the initial aggressor. The defendant was the first one to use force. Based on these facts, self-defense is not applicable. Next, you're given instruction on extreme mental or emotional disturbance. This is a long instruction. We'll keep it simple. There's no evidence that the defendant was acting under extreme mental or emotional disturbance when he tried to kill Ariel. Don't be confused by his testimony. He did say he was under severe emotional distress, but he said that after he tried to kill Ariel. He said he was under severe emotional distress after he started to think about how this would affect his job, how this would affect his life. He was under severe emotional distress after he began to think about the consequences of his actions and how his actions would affect himself. That's what that is. The defendant was not under extreme mental or emotional disturbance when he tried to kill her. He only became that way when he began to think about the consequences. The second part of that instruction states that the defendant's self-control, the defendant's logical thinking is important here. It shows the defendant, when plan A didn't work, he moved to plan B. When plan B didn't work, he moved to plan C. And when he got caught, he fled the scene, he hid the evidence, and he hid himself. That shows the defendant was using logical thinking, the defendant was solving problems as they came, he was not acting under extreme mental or emotional disturbance. Okay. You got a list of other included offenses. You got a list of a bunch of assault charges that are included in the attempted murder and second degree charge. When you think about those, just think one thing. He did more. This is what he did. Assault in the third degree, causing bodily injury. Ladies and gentlemen, that means physical pain. He did more. He did more than cause physical pain to Ariel. Assault in the second degree. He did more. Yes, the defendant caused a major laceration to Ariel's head, or severe laceration. The defendant caused a bone fracture to Ariel's thumb. Yes, he did those things, but he did more. But he did more because he was trying to kill her. Attempted assault in the first degree, same thing. Defendant took actions that he knew would cause a substantial risk of death. Yes. But he did more. Because the evidence all shows that defendant wasn't intending to do an assault. The defendant was intending to kill. All right. 3 things. Motive, a beating, and a confession. You've seen through this trial the defendant's motive. He was upset. He was angry. Wherever he turned, Ariel wasn't being punished. First, he talks to Ariel's best friend, tries to air the dirty laundry. But the best friend stays on Ariel's side. Deanna stays on Ariel's side. She's not punished. Then he emails Andrea Miller. Giving this other woman Ariel's personal contact information, her cell number, her personal email. But Andrea Miller never responds. Ariel's not punished. And then he goes to counseling. They go to marriage counseling. And instead of focusing on the affair, what do they focus on? These intimacy issues, these issues that Ariel testified about, these issues that were defendant's fault. Everything the defendant tried to do made sure Ariel was never punished. So he did it himself. Every response defendant had to this emotional affair showed the defendant's need to control Ariel. He wanted to control where she lived. He wanted to separate this woman from her 18-month-old child. That was his response. His response to finding out was, you should move out. He wanted to control her job. He wanted her to quit. He wanted her to be dependent on him. Because once Ariel quit her job, it's much harder to divorce. She has no more income. She can't go find another remote worker, nuclear engineer job. The defendant knew how much a divorce would cost. He was looking at his own documents, his own records from his prior divorce. He was looking at his own records that showed how much he paid in his prior divorce, because that's what he was thinking about. He was doing that math. He was doing that math on what it would cost to divorce Ariel, what he would give up. And he just couldn't stop thinking about it. He couldn't stop thinking about this emotional affair that he's built up in his head. And because he couldn't stop thinking about it, he made a plan. He made his plan to kill Ariel. The beating. Plan C, the third substantial step, the one that's the most visible, the one where she got these injuries. The defendant took the rock. He picked it up. He swung at Ariel again and again and again and again and again. That many swings shows that the intent was not just to hurt. It was not just to defend. The intent was to end her life. That's what the number of swings tells you in this case. Ariel's only relief, the only thing that stopped him, was the defendant being caught in the act. It was the intervention of Amanda Morris and Sarah Bucksbaum. That's it. So we end with the confession. 10:42 a.m., just a couple minutes after this happened, the defendant calls Emil. It's a video call, not a phone call. So Emil could see what the defendant was saying. He could see the defendant's face. He could see the defendant's mouth moving. There's no gray area with this confession. As Emil testified, he has no doubt about what the defendant told him. There's no phantom gust of wind that came up. There's nothing like that. The defendant confessed to Emil. He told Emil that he tried to kill Ariel. He told Emil why. He told Emil that Ariel got away. He told Emil that Ariel was having an affair. That doesn't sound like a goodbye suicide message, does it? He told Emil that he was at the end of this rope. And think back to the last thing that the defendant told Ariel before he tried to kill her. He told Ariel, "I'm sick of this shit." That's corroborated that he's at the end of his rope. Same idea. What didn't he tell What didn't the defendant tell Emil? Nothing about self-defense. Nothing about Ariel attacking him. Nothing about what he testified to you. Is that reasonable? Does that make sense? No. 10:42 a.m., the defendant FaceTime video calls Emil. He confesses. And Emil's next step, after being put in that situation, after being put in a situation as a 19-year-old that he had no want to be part of, Emil does what he does. He goes and tells his grandparents. He goes and tells them what the defendant said. And Judith Mast, ends up texting the defendant. 11:33. She texts the defendant, "Is Ari okay?" She asks the defendant about her daughter. And the defendant says nothing. He doesn't respond. But what he does do shows his intent. What he does do, he calls Emil again, and he asks him, "Did you tell anybody?" That shows the guilty conscience of the defendant. That shows that the defendant was not acting in self-defense. That shows the defendant was thinking about what his actions would do to himself. He was thinking about himself. He wasn't thinking about Ariel. He wasn't thinking about her condition. It was only himself. So, ladies and gentlemen, there's one verdict and only one verdict that does these things. There's one verdict that holds the defendant accountable for what he intended to do, for what he tried to do to Ariel. There's one verdict that's supported by the physical evidence, the digital evidence, the corroborated testimony of witnesses, and the defendant's own confession. There's only one verdict that's corroborative, that makes sense with all of that. There's only one verdict that the evidence and justice demands. And that verdict is that you find the defendant guilty as charged of attempted murder in the second degree. Thank you.
Thank you, Mr. Gardner. So, ladies and gentlemen, this is our second morning recess. Ms. McCallum will come get you, I'll just say 11:10. We'll reconfigure the courtroom during the recess. We will come back. The defendant will have the opportunity to present the closing argument. All rise.
Court is on a short break. They will be returning about 10 minutes or so. And this was the state's closing arguments you just heard. Next will be the defense closing arguments, and I would assume at some point the jury would deliberate, and then it will be, we'll see if they have a verdict, maybe today or tomorrow, whenever. We'll see if he's guilty or innocent. So that is it so far, and I think he did a very good job. The prosecution, the DA, he did very good presenting his case, and I want to say that both the defendant and Ariel both of them did well in the stand. So pretty good trial, although it's under dark circumstances, of course. So yeah, we are on a break. We will see what happens next shortly. Oh, absolutely, Saul Girl. I agree. Very good point. He made it short and sweet and simple. He didn't go too long with it. That is true. And we have Miss C says he gets rebuttal. Yeah. There's also a rebuttal. I forgot to mention that the prosecution most likely will do a rebuttal where they will rebut what the defense says. Zero says, what can the defense say about that brought her on the hiking trip and lost his nerve until the argument? Well, this is the thing about that is very good question. The point here is, I will say the defendant, when he was on the stand, which his testimony on the stand I recommend seeing, it makes things make more sense. But what happened is, on the stand, it wasn't like a moment where he all of a sudden exploded on her, right? It was over time. What the defense would argue is he was being cheated on, and she would not stop talking to this other guy, and it kept on happening and happening until the point where it's like if you have a pressure valve that eventually blows up, right? Or a volcano that goes off. It was over time. He kept on being pressured and pressured until he snapped. It wasn't like a one-time thing. It was what he was going through over time that, and seeing her messaging this other guy, and it happening, over again, and she's not, he was trying to save the marriage. They did marriage counseling, but it wasn't really working, and this kept on happening, and allegedly she was going to go on a trip with him somewhere, and so he just snapped. Now, conveniently, yes, it was in this secluded jungle area where it all happened, not at Walmart. I agree. But still, that's what the defense would argue. Now, the prosecution would say that, he was trying to maybe plan it out and had a violent situation. So, but that's what the defense would probably argue in that situation. Doesn't change the fact that you brought her there to delete her. That's the question of the hour. Yes, in that moment, she could have passed away or been murdered. Yes, in that moment, correct. The trial is about if before this happened, if he was if months before this, he was going to think about, I'm going to bring her to this area and have her deleted. It wasn't about if he assaulted her and try to delete her there or not. The trial, trial stuff is tricky. It's about, did he premeditate this beforehand to take her out? Or was he really trying to bring her on a hiking trip for her birthday? They got into an argument and he just snapped. That's if he's guilty of trying to take her somewhere to delete her, or was he in the moment just snapped? That's what it's about. So if he snapped and it was in the heat of the moment, he would not be guilty of premeditation. But you could have some other thing happen where he's guilty of attacking her, assaulting her, trying to delete her in the scene. Yeah. So yeah, that's just how these trials work and like the way it's orchestrated. It could sound very bizarre and kind of strange because you would think logically he's guilty anyway for attacking her in the first place. No, it's if he premeditated it or not. It's kind of confusing. So that is what the trial's about. Now, as I said, it was very wrong what he did, and he shouldn't have done that, and he shouldn't have snapped. Yeah, I agree. This is a really messed up thing he did. But it's up to you all also to think if did he premeditate it or did he not premeditate it. And Miss C said he kept telling her to get closer to the edge. Right, and yeah, that is what the prosecution and what Ariel says. And now what the defense would argue in his side of the story is that he was by the edge and she pushed him, then they got into an altercation, and he went off, was either pushed off the cliff or fell off the cliff. They got into a fight, and all that happened. So if you all think he's guilty, then that is fine. If you think he's not guilty, that is okay too. It's whatever people think it is from the information that's given. All opinions are welcome. Prosecution arguments may say that if he wanted to take her life, he could have done it while she was sleeping, or done it all at night. That is something he could have hypothetically have done. That's something they may argue. There was, although like what Miss C is saying, that he could have thrown a syringe off a cliff and they didn't find it. Okay. It's just technically, according to this like law stuff, if it wasn't found, it's not in evidence, it's not considered. But it doesn't mean it wasn't thrown off a cliff or he hid it somewhere. And the other argument they might try to say is if he's trying to hold her down and she's fighting back and all, it would be difficult to inject her with something while she's fighting. If she's sleeping, it would be easier to inject her with something. But that doesn't mean he didn't try that, or he didn't try to delete her another way. So, yeah, it's up to you, as I said, to think if he's guilty or not. But that's what the defense would say. That's what the prosecution would say, in that circumstance. But what he did was definitely atrocious. Definitely. And now we're back.
5-373, Attorney Vice President Corley, Lawful Counsel of Record. Jury is absent from the courtroom. Counsel, you want to see it. Mr. Garner, you wanted to take up objections to defendants' proposed closing slides.
Yes, Your Honor. The first is on slide number 14 on page 5 of the printout that defense counsel handed to both of us. It's a slide that says examples of deceptive behavior. I do believe this is impermissible argument that is essentially stating that Ariel has been deceptive in the past. It's an argument that is trying to make a 404 argument that says that she is deceptive now. That is the one reason under HRE 404 that you cannot use prior bad act evidence for. It is explicitly stated that you are not allowed to use prior bad act evidence to show conformity therewith, and that's exactly what this slide is attempting to do. So we'd strenuously object to introducing this, using this slide, using this argument that is against the rules of evidence. It's asking the jury to consider something evidence for an inadmissible purpose. So I do believe that's not appropriate. And that's the first objection.
We'll start with Defendant Siriato. Mr. Otake.
Your Honor, obviously her credibility is at issue, and there's been multiple examples in this case that has come up in the evidence about deceptive behavior, and it is critical, obviously, that we be able to point that out. So I've never heard of, we can't point out in closing how a complainant has been deceptive or dishonest. I mean, he just spent half an hour saying how Gerhardt was dishonest. So obviously that's fair game in any closing argument.
Anything else you want to add?
The issue is not commenting on the evidence. It's inviting the jury to not follow the law. That's the issue here. They are allowed to comment on the evidence that was introduced at trial, and I understand that. But what this is asking is not that. It's asking the jury to consider this evidence as, again, under the only improper purpose under 404B, conformity.
Understood. State's objection is overruled. The defendant will be allowed to argue the complainant wins his credibility. It might be inadmissible under 404 with no exception of 404B, but there is the avenue of admissibility to have found credibility with specific instances of conduct in those 608. So the state's objection is overruled.
The other objection from the state is somewhat throughout the defendant's proposed closing argument. There appears to be snippets of transcripts. And they appear to have been, some of them highlighted, some of them not. As the court and everybody here is well aware, the jury will not have transcripts available when they go into deliberations. They won't, and these transcripts are purported to be of the testimony during the trial. So they're not transcripts that were identified as exhibits and introduced into the trial. They're transcripts of the testimony of the trial. Everyone's aware the first question the jury always asks after going to deliberations is, can we have a transcript of the witness's testimony? And the answer is always, transcripts are not available. So it's not fair to the jury. It's to put these essentially unmarked exhibits into the PowerPoint. It does give undue weight to what that is, especially consider the jury is instructed to remember the evidence on their own rather than what a court reporter may have written, that it essentially gets around that instruction that the court gave to the jury. It puts undue weight on only these portions that the defense wants to put weight on. So I do believe it's not appropriate for transcripts to be referenced, trial testimony transcripts to be referenced in closing argument.
Can we drill down on that a little bit more, Mr. Garner? The real objection is the form with which they're displayed. Because if it wasn't question and answer, and it was just not even the paraphrasing, if it was just the verbatim testimony without the Q&A descriptions, that would not be objectionable.
That's correct. And that's why putting it in, this format with the new Courier font, when it's clearly a transcript written by somebody else, gives it undue weight. It takes away that.
Sorry, it's not the font. Only we know it's Courier font. But it's the format of the Q&A.
Yes. That's the main reason.
Okay. Mr. Otake.
Your Honor, I've done this in many trials. It's pretty commonplace. I've done it in civil trials, I've done it in criminal trials. We took the time and money to order the dailies, and it's what was said in court. It's the best evidence of what was said. And I'm just, whether it's in that format or another format, it's the same substance. There's nothing improper about doing this. I've done it many times in many courts. They had the option to order the transcripts and use their government resources to pay for it. They chose not to. And so this is what was said in court. And I'm not taking it out of context. I'm not going to argue it inappropriately. You know, I'm not going to, I mean, it's just what was said. It's I don't know if, I mean, what font it's in or what, like, it is what was said. And we chose to order it and pay for it, and I've done it many times. And I'm not aware of any rule that says we can't do this. So I'm asking that the objection be overruled and we get on with closing.
Anything else you want to add, Mr.
No.
Slides with the transcripts, and they are in fact transcripts, there's no dispute about that, are not, they're the actual transcripts as represented by counsel. It's not a misrepresentation of what was said. It's not even a paraphrasing of that. Well, I'm uncomfortable about the form. At this point in time, I'll overrule the objection and allow the parties to proceed.
Thank you, Your Honor.
What has been provided to the court will be made part of the record to document the state's objections. It will be court's exhibit 1 for trial and be part of the record.
And Your Honor, I did show the state some demonstratives. I would like, Dana, I don't believe they have an objection, but it's going to be facing away from you, so I'll show it to you now.
Please.
This is the first one. Accurately describes page 2 of the instructions.
Okay.
And then, oh shoot. Darn it. This is the second one.
Mr. Gordon, no objections.
To these two demonstrative aids, no objections.
Anything else we should take up before the jury returns?
No, Your Honor.
Nothing from the state.
Actually, can we approach really quick? Sorry. On the record, it's fine.
Off record?
On record.
Okay, sure. record. All jurors are back in the court. Ladies and gentlemen, thank you very much for your patience. Before we hear from Mr. Otake, the argument that State made about justice requiring a particular verdict that Mr. Garner made right before we ended is stricken from the record. You are to return a verdict based on the evidence that's presented, or the lack of evidence, or reasonable inferences therefrom, as well as the court's instruction on the matter. Mr. Otake, are you ready to present the defendant's closing argument?
I am. Thank you, Your Honor.
Please.
Good morning, ladies and gentlemen. I want to begin by thanking you all for your time and dedication to this case. Most people serve on juries a couple, 2-3 days. You guys have been here for close to a month now, and I want to just express heartfelt thanks for that. It was your time and doing that that made sure that Gerhardt got a fair trial. That's what this was about, and we appreciate your time tremendously. You know, we're at the end of the trial here, but I want to actually circle back to the very beginning. The very beginning, jury selection, and remind you guys about that. Multiple days, started off with 200-something jurors, whittled it down, excuse after excuse, people couldn't be here, couldn't be fair, couldn't set aside what they heard, weren't willing to give him a fair shake. And we whittled it down to less and less and less, and we ended up with the 16 of you here. And it wasn't by accident. It wasn't by accident. It's because we saw in you what we were looking for. Jurors that would wait until you heard everything. Jurors that weren't going to convict somebody based off of media reports. Jurors that weren't going to just look at one side of things. Jurors who had logic, reason, and common sense. And most importantly, jurors who had integrity to follow the law on reasonable doubt.
Objection, move to strike. None of this is evidence.
This is statement. Please continue.
So I'd like to move to strike the entire closing argument up to this point.
Sustain the objection. Mr. Otake, please continue.
We went through that process. You guys promised us you would do certain things, and we knew that you would. Now, I'm going to walk you through the evidence and the law today, and it'll be clear that there's reasonable doubt all over this case. All over this case. Before I do, he wants to, whole unwilling, unfaithful, unwilling, untrue. We talked about that. He wants to say unbelievable. I'll add another unword. Undeterred. They're undeterred by the evidence. It doesn't matter what it shows. They're going to spin it in their favor. They came up with a theory and they went to search for facts to support it. They didn't look at the evidence and say, what's the theory that points that out? They came up with a theory and they tried to find any fact they could to fit it. They were undeterred. Undeterred by the DNA. The DNA shows, and I'm going to go through it, she's holding the rock. This is a trillion level DNA on the unstained side. Undeterred. Oh, must be because when she was blocking. Undeterred. The computer, I have to call Inuma again to say that sometimes the computer accesses these files. Undeterred. Still shows that he's looking at this credit card statement from 2018 to show that he has a financial motive, that it's cheaper to kill her than divorce her. Undeterred. Undeterred by the fact the eyewitness picks the wrong person out of the photo lineup. And still, she stared at him, looked into his cold, dark eyes, saw him very clearly. Picks out the wrong person. Undeterred. Undeterred by the bruise on his face. Oh, maybe it's dirt. Maybe it's dirt. Evidence should lead to theories. You don't come up with a theory and then search for evidence to spin it to fit your theory. That's what happened in this case. Ladies and gentlemen, I'm going to go through just some of the law initially, and then we're going to come back, go through all the evidence, and then I'm going to come back on some other parts of the law. So I want to start off first by reminding you, as you know, you took an oath, right? You told us that you would give your word that you would follow the law. You'd follow the law, and we know that you will. I want to start, you can follow along in your instructions if you want. I'm just going to start on page 2. Page 2. I talked to you at the beginning about these 3 principles of justice and fairness that keep our system safe for all of us. Anytime the government waves its accusatory finger at anyone, these principles kick in, and it's a safeguard. It's a safeguard, and that's summarized on page 2. You must presume the defendant is innocent of the charge against him. This presumption remains with the defendant throughout the trial of the case unless and until the prosecution proves the defendant guilty beyond a reasonable doubt. The presumption of innocence is not a mere slogan. Not a mere slogan, but an essential part of the law that is binding upon you. It's binding on you. It places upon the prosecution the duty of proving every element, material element of the offense charge against the defendant beyond a reasonable doubt. Now, I'm a visual learner. I had this chart earlier to help you guys understand how that works. We talked about how the presumption of innocence, you don't start in the middle. You don't start in the middle. It requires that you start here. You start here. It requires that. And then there's a gap. And it's a proof gap. This has to be filled with proof beyond a reasonable doubt before you even step this way. Before you even step this way. If there's no proof beyond a reasonable doubt, you don't move. You don't move. And let's look what a reasonable doubt is. You must not find a defendant guilty upon mere suspicion or about evidence which only shows that the defendant is probably guilty. Probably guilty is not good enough under the law that you took an oath to uphold. What the law requires, ladies and gentlemen, what is required by law before the defendant can be found guilty is not suspicions, not probabilities, but proof. And think about that word. It's a strong word. We don't pay enough attention to that word. Proof. That's a powerful word. Proof of the defendant's guilt beyond a reasonable doubt. That's the law. Probably not enough. That's the law. Again, visual learner, I have a chart to help you with this. This chart summarizes page 2 in a more simple way. State's burden, it's their burden, right? We talked about they brought the charge. Make no mistake, this is not Arrow Koenig versus Gerhardt Koenig. This is the state of Hawaii versus Gerhardt Koenig with their resources, the police force, their computer experts, their everybody. Their burden, state of Hawaii versus him. This is their burden. If they only provide, if obviously 100% you think is not guilty, not guilty. Probably not guilty, not guilty. Possibly not guilty, not guilty. Maybe not guilty, not guilty. Maybe guilty, not guilty. If you're like maybe, maybe not, if you're left thinking, I don't really know what exactly happened, maybe, maybe not. If you're here, not guilty. Possibly guilty, probably guilty, not guilty. That's how high the burden is. It's a safeguard against convicting innocent people. This is what you took an oath to uphold. I'm going to circle back to this, but this is what you told us you would apply. Now, I'm going to go through more of the law later, but just very quickly, the law on attempted murder, the elements are on page 14. Page 14. Before we go through the evidence, page 14. Second paragraph. A person commits the offense of attempted murder in the second degree if he intentionally engages in conduct which, under the circumstances as he believes them to be, is a substantial step in the course of conduct, intended or known to cause the death of another person. That his intentions was to kill her. That was his intentions all along. That's what they have to show. It goes down, paragraph 1, the elements. The defendant intentionally engaged in conduct. And 2, the conduct under the circumstances as the defendant believed them to be was a substantial step in the course of conduct intended or known to be practically certain by the defendant to cause the death of Ariel Koenig. That's what they have to prove, more than maybe, more than possibly, more than probably. That his intention and his knowledge was practically certain he was going to kill her. That's their burden. That's what they have to prove. We'll come back to this. There is an instruction on self-defense. I'm going to talk about that at the end after we go through the evidence. They are the included offenses. I'll walk you through those as well. But let's now look at the evidence, and it'll be clear there is just massive amounts of reasonable doubt. So the first thing, one second here. this issue about, was this planned? Okay. Was this planned? This big plan, he just went through this motive, that Gerhardt Koenig, you got to know him, that he came up with this plan in late December, that it was going to be cheaper to kill her than divorce her. Was this planned? Let's look at the evidence. Is there a reasonable doubt about that? Let's walk you through that. First of all, she brought up the idea of going on a trip to Oahu. That was her idea. Why would that be the plan? If you're planning on killing somebody, you're an anesthesiologist, you have access to, as they fault him for being a doctor, I'm going to get into that a little later, having these things at home that he uses to save people's lives, that your plan is, let me not stay on Maui, where there's probably 800,000 less people and more secluded areas. Let me sneak syringes through TSA onto an airplane, come to the busiest island there is in Hawaii, 1 million people, go to a place, a trail, a parking lot I've never been to, that I'm not familiar with, and in broad daylight, 4 minutes from a very busy parking lot, I want to try and kill her. That's the plan? That makes absolutely no sense. Logic, reason, common sense. Why would you do that? The life insurance issue. Well, this is the busy parking lot. So, I apologize. You saw this in, this was the plan, to come here. With all these cars, all these people, he says 99% don't hike or whatever. He didn't know that. He put in here, this is the plan, according to them, that he's going to come to this unknown place with all these people, all these cars, and try to kill his wife, instead of just doing it on Maui. That's the plan, according to them. The life insurance issue. Now, this shows two things. I mean, we're going to get into later about how he told her about it that morning, and she learned that morning if something happened to him, she would get $1.5 million. But it's relevant in another way. If in December and January and February, you're planning to kill your wife, why are you going through the process of obtaining $1.5 million on your life for her? That's not the sign of somebody plotting to kill somebody. That's a sign of somebody trying to work on, okay, look, we got to figure this out for our kids, and if something happens, there's, He's not planning to kill her. Now, the birthday card. He writes this morning. It's the only time she got emotional because she knows it was genuine. And I'm going to talk about that more later. He writes this. There isn't an obstacle in this world too hard for me to fight through for you. I would take on anything just to see your smile. You're one of the kindest, most giving, and selfless people I know. Selfless people I know. Putting others before yourself. So much love. You're the heart of our family. Fun, fearless, and a terrific mom. The kids and I hit the jackpot with you. He meant that. You don't write a letter like this because if you're planning to kill somebody 2 hours later. There was no plan. There was no plan. The Fed reservation. He made a reservation to go to dinner that night. He's not planning on killing anybody. There was no plan. This is from that day. They're having a great trip. They had gone through some rough times, but they were making some progress, in part because they weren't really talking about it. And that's why she felt comfortable. I'm not saying she was trying to hook up with Miller again. She wanted to travel for work. And that's why she felt comfortable bringing, hey, we've been making progress, but, I got to travel for work, And then she says, my mom can come with me. That's what Gerhardt told you about. So this is them on the trip, the day before. This so-called big plan. There was no big plan. Now, why are they committed to saying that there was this pre-plan and financial motive? Well, because of course. It makes no sense anyone would have syringes on this hike unless this thing was pre-planned from earlier. So they have to stick to that, even though it makes absolutely no sense. There was no plan. And I got to tell you, I got to tell you, okay. When they get into the fact that in like December or whenever it was, there's a text message where she's like, are you coming home soon? And he's like, this lady just got hurt on a hike and a rock fell on her, so I'm trying to save her life. The fact that they're trying to say that at that time, the light bulb went on in his head and he was like, I got it. I can kill her on a hike with a rock.
Objection.
That's
Drop your
ridiculous.
argument.
That's ridiculous.
And move to strike.
Granted, that's argument restricted.
Okay. Well, that's what he was pointing out. Okay.
Objection again to improper argument.
Sustained.
The idea that he came up with this plan because he was trying to save a patient's life who was hurt with a rock on a hike is ludicrous. So, ladies and gentlemen, as much as they want to avoid it, as much as they try to talk about witnesses and corroborations, the reality is this. What happened on the mountain before the hikers got there, it is essentially she said, he said. The witnesses told you. They didn't see much. One witness only saw one hit, the other didn't see a hit at all. One of them picks out the wrong person in the photo lineup. Okay? Everything before that, they told you they can't say what happened, they don't know how it started. It's she said, he said. Now, by the way, these witnesses who apparently stood there and stared at him for 30 seconds, looking into his deep, cold eyes, they didn't see no syringes on the ground. You know the one she says she flicked out of his hand that landed right there? They're nurses. They didn't see that because it didn't happen. The point is, ladies and gentlemen, when it's your burden of proof, it's this high, and it is she said, he said. Your she said better not offend logic, reason, and common sense. Better not offend be contradicted by the physical evidence. Better not be highly motivated. Better not have examples of many times where she was deceptive to the police and to you. And all of those are present with her testimony. I'm going to walk you through that. Now, logic, reason, and common sense. The bottom line is aerial cloning is not reliable. It's not reliable. We talk about credibility. The question is reliability. Okay? Logic, reason, and common sense. We don't ask you to leave that at the door. We want you to bring that in here and look at what was said. Let's look at what she said, right? I mean, basically she's saying she wouldn't take the selfie, and then he was like, I'm tired of this shit, let me throw you off the cliff. And then he tries to stab her with a syringe as he's loading it first, and then he bashes her up to 10 times. That's her story. Okay. First of all, the way she describes it makes it sound like he had multiple arms, like an octopus. She says that she's covering, he's on top of her, covering her mouth, and then he has a syringe, and then he's loading he has a vial, and he's loading it, but he's holding her down.
Misstates the evidence.
Sustained.
Can we approach, Your Honor?
Sure, come on up.
The inference is, why would you have a vial unless you're trying to load it? He has a syringe in his hand. The other hand, he's holding her mouth. He's down on top of her, doing all of this while she's supposedly kicking and fighting. He only has 2 arms. And in the middle of it, they're having a full conversation. Your mom's not going to be very happy if you do this. You know, the kids aren't going to be, you know, her story makes no sense. Now, logic, reason, and common sense as we look at her story, and it is a story, okay? If we look at her story, if this was a big plan that someone's going to bring a syringe to incapacitate somebody and stab them to make it easier to throw them off the cliff, don't you think they would load the syringe ahead of time? Don't you think they would load the syringe ahead of time? Their story is that that's the plan, and in the middle of it, he's like, oh wait, I gotta take out this vial and get it ready. That makes no sense. Especially given the fact that it's undisputed, he had just gone up the mountain by himself for 10 minutes. If he had it and wanted to use it, he could have loaded it. It makes no sense because it didn't happen. It didn't happen. The other thing, and I'm glad he brought up this thing about plan A, plan B, plan C, because it proves the point I was going to get to. why in the world, if you bring a syringe to incapacitate someone to make it easier to throw them off the cliff, why would the syringe be plan B? It would be plan A. You would use the syringe first, and then you would throw them off. You wouldn't start the scuffle and make that, start this scuffle and then be like, oh wait, now I'm going to stab her with the syringe. That makes no sense. It makes no sense that, that's the plan. He knows if something like that happened, he's a doctor, and toxicology report would show propofol in her thing, in her blood, that this is.
Objection, not in evidence.
It makes no sense that he would start the scuffle before using a syringe if that was his big plan. Because it didn't happen. This idea that she could just flick the syringe out of his hand, he's holding it tight according to her, he just flicks it. None of that makes any sense. This idea about, well, he hid evidence. The rock is found right there. We don't know exactly where because HPD should have photographed it before they moved it. But why would he get rid of the syringes and leave the rock? None of that makes any sense. And then, of course, we get into him leaving her on the mountain. Leaving her on the mountain. If this is the big plan to use this hike as an opportunity to throw her off and kill her, why would he walk away and leave her there alone thinking he's going back to the car? And they're trying to say, well, all kinds of things about that. But the reality is this. If you think, even though it's not true, if he went off on his own, because if she said, well, it's too high, I'm getting a little scared, and his plan was to kill her, he wouldn't leave her. He would say, okay, you know what, that's fine, but let's just at least go over here and take a selfie and then try to throw her off, right? He wouldn't have left her for that reason. If he was planning to try and throw her, he would have stayed with her. And then her rationale, to get around the idea that, undisputable, that she clearly said, when he got back, she told the detective that he said, oh, you're still here. He was surprised that she was still there. She says, well, he knew I meant I was going to go exploring in that area. Where was there to explore? We heard from witness after witness. It was you either go up or you go down. You don't go off and go exploring. That was her way to try and cover up. That it was clear he left her thinking she was going back to the car, which you wouldn't do if you had a plan to kill somebody by throwing him off the cliff. PSA, we've all been through it. Sharp metal syringe objects, sharp objects, not going to work. Not going to work. Logic, reason, common sense, that he has this intent to kill her, but then he lets her crawl away. He lets her go down to the witnesses. Doesn't come after. Doesn't make any sense. Her demeanor. They say, oh, she was very matter of fact and just told it. Ask yourself, if someone's describing what should have been the most horrific thing they've ever been through, bloody murder, someone's trying to stab you with a syringe, a monster's trying to throw you off a cliff, when you're recounting that, you might get a little emotional. Not at all. And she's not just someone who doesn't get emotional, because we saw her get emotional when we showed her the card. When she read the birthday card, she got emotional. I submit to you that was probably guilt, but whatever it was, she knew it was genuine, and she showed an ability to show emotion. That was real. The card was real. You cannot get emotional over a made-up story that didn't happen when you started the fight. Reasonable doubt. Logic, reason, and common sense. Now, Ariel's story contradicts the physical evidence. It just does. And this is a huge problem for them. And they try to come up at the last minute with, well, maybe when blocking it, her DNA got on it. But let's talk about that. Because we're talking more than probably, right? He wants to say maybe blocking her DNA got on it. Maybe. Okay. But let's use our logic, reason, and common sense and look at the physical evidence. What does Scott Henderson say? The DNA guy. Generally, yeah, you could expect higher likelihood ratios with the more DNA that's present in a sample. The more DNA present in the sample, you can expect a higher ratio, yes? Generally speaking, yes. The more someone's DNA is on the sample, the higher the number. Higher the number. He then goes on, we learn from him and Amarin, that, very important, the rock, swabbing from the unstained area. There was a stained area that looked like blood, and there was the unstained other side. They swabbed the blood, they tested, of course it's Ariel's blood. I told you that in opening statement, right? The blood side was Ariel. The stain side, they don't test for blood. They test for human skin cell touch DNA from people holding objects, they told you. Okay? The unstained side had a profile for two people, Ariel and Gerhardt. Ariel's number was 1 trillion. His was 290. Let's go back to what Henderson said. The more DNA present on the sample, you can expect a higher ratio. Yes, yes. 1 trillion to 290. The rock was in her hand. The rock was in her hand. The DNA shows that. That blows away her whole story. That she didn't have the rock. The rock was in her hand. Her DNA is all over that. This idea, well, maybe when she was blocking it hit her, that's not going to lead to that much of her DNA on it, more than him.
Objection, speculation.
If he's holding the rock the whole time and she's just blocking, there's going to be more of his DNA than hers. She was holding the rock, and that blows away their entire theory. Scientifically, I asked Amarin, what about scientific evidence, Miss Amarin? And we talked about it. It's unmotivated. Scientific evidence is not trying to get full custody. His retirement. It doesn't lie. It is what it is. And they may say, well, maybe it was there because of this. Again, maybe, maybe not. A huge reasonable doubt. A huge reasonable doubt. She had the rock in her hand. 1 trillion to 290. Now, the other thing about the physical evidence is the injuries. They want to say, we heard about the stellate laceration. I'm going to talk more about it later. But it has one point and it spreads, right? And you heard. She at the end said she doesn't know how many times she was hit. The doctor, Grosjean, said 2, maybe 2. I cannot say how much more. Dr. Arden says 2 to 3. Okay. If she was hit 7, 8, 9 times with all his might, it would be way worse. Physical evidence doesn't support her version of events. Also, if she's under attack, she's going to be scratching, doing biting, as she says. He has no scratch marks, defensive wounds. There's no bite mark on him, even though she said she bit him. The physical evidence doesn't support her story. And that's a huge problem when it's this she said, he said, and this is your burden. That's a huge problem. Further problematic is the examples of deceptive behavior that we saw through her. Many examples of deceptive behavior that makes her unreliable. We heard about her deleting the text messages to hide it from her husband, to hide the extent of a relationship. That is inherently deceptive to do that. That's inherently deceptive. Now, the affair. Look, I'm not the morality police, okay? I'm not here saying she's an awful person because she had an affair. That's for you to decide, okay?
Objection,
The relevance.
improper.
Sustained.
And move to strike.
Granted, last argument of morality is stricken from the record.
The relevance of the affair is primarily that she lied about it to the detective. The context is showed in the relationship in January, February, and December, but the relevance is she lied about it to the detective. And that is incredibly important when it is she said, he said, and is proof beyond a reasonable doubt. Let's look at this. This is, he said, well, she describes it to the detective as just some flirty text messages. He says, well, there's nothing in the text messages about sex. Well, she deleted most of them, so we don't really know what's in there. But we do know what we saw. On the trip, the day before he's going to confront her, this is at 11:22 p.m., presumably Hawaii time, or maybe it's California time, whatever, but it's late at night. She's sending this to Jeff Miller. Jeff Miller is sending her this. They have a nickname for Gerhardt, HALEU, which is that radiology, nuclear, whatever. They call I have HALEU. They have a code word to let each other know when he's around. She's listening to an audiobook, How to Help My Spouse Heal from My Affair. That's what she's listening to. He says to her, you're engaged and continue an elaborate secret affair instead of coming to me asking to work on our relationship. And her response is, if anything, I learned how stupid it was this time and I know how to make sure it doesn't happen again. That's her response. Okay? Now, to the detective, no affair, just some flirty text messages. To you guys, no affair, just some flirty text messages. You saw 12/1, December 1st, all day long on a Sunday. Good morning, all day long, all day long, all day long, good night. And that's how she says it to the detective. She was misrepresenting, deceptive, and lying to the detective. Further examples of deceptive behavior is what she does with her primary care doctor and the records. After the fact, she tells her primary care doctor in an email to add, can you add traumatic brain injury? I want to make sure the documentation is consistent between my care at Queens back here in Mount. And that's the important part. Why is that important? Because, number one, she says she doesn't recall reviewing the Queens records. The Queens records doesn't mention traumatic brain injury. Arden told you that, the two don't you think if traumatic brain injury was in her Queens records, they would have asked Grosjean or Carlton Whitney that? It wasn't in there. So this shows she is not just asking the primary care doctor to do this, she's deceiving the primary care doctor into believing that the Queen's record said traumatic brain injury, so the PCP will be like, oh, okay, I'll add it. It's deceptive behavior. It's incredibly misleading. Now, she says she's surprised about the work bag. She's surprised about the work bag. Oh, I didn't know. You know, she knew he had it there. She knew there was syringes and vials in there. She calls her attorney, and then they turn it in and say, "Oh, surprise! Look what I found." She knew it was there. She knew it was there. She lied about that. She lied about her affair. She lied to her primary care doctor. You know, there is I really like quotes. So there's an author, famous author, by the name of Samuel Clemens. Most of us know him better as Mark Twain. Mark Twain was giving a speech once to some young people about the dangers of being untruthful. And what he said was, you ought to be very careful about lying. Because once caught, you can never again be, in the eyes of the good and the pure, what you were before.
Objection to improper argument.
You guys come in here, you give people the benefit of the doubt. They come in here, you say, I'll hear them out. And then they lie about different things, they deceive. In the eyes of the good and pure of all of you, you can't look at her the same again. It's dangerous. It's dangerous. If she's going to manipulate her PCP doctor, if she's going to be deceptive to the detective, do you think for a second she would hesitate to be that way with you? And then we get into bias, interest, motive. We talked about this. How she knew a divorce was coming. She wanted full custody, how they're using these allegations against him to get full custody, to make it where he can't ever see his kids again, to get half his retirement, to get all of the house, things that she might not get. She knows that. She said to you that their statement is, we want full custody, but if depending on the outcome of the case, that can be revisited later. She knows the ramifications. Now, let's compare that to Mr. Gerhardt, Dr. Gerhardt Koenig. You got to see him. Trust your gut. Trust what you know about people. Is he somebody that is a monster that came up with this plan to stab his wife and throw her off a cliff? Is that the sense you got from him? Or was he a hurt human being struggling with infidelity but trying his best? You know, they talked about his parents, how they moved from South Africa when he was young. He worked really hard to become a doctor. This, he talks about, oh, she was trying to control everything about her. All of this awful controlling guy. What does she say? Prior to December, you generally describe your marriage as good, right? Yes, sir. This is what Ariel said. You don't describe your marriage as good if somebody is a controlling, coercive, violent person. There's a lot embedded in this. You don't describe it as a good marriage if somebody's, unless they're a good dad. Look, domestic violence is horrible. There's some awful men out there that use their power, control, financial means to control women in improper ways. This is not him. That's not him. She wouldn't say it was a good marriage if he was like that. His version of events, they fault him for wanting to see her phone and things like that. The audiobook said that's what it takes. This is Ariel. I asked you earlier, you understood the audiobooks you're listening to by these professionals says to give up privacy, give up access, get them to trust again. She says yes. They're faulting him for the professional advice, what is said. He's not trying to deprive her of her career. He's trying to stop her from seeing the guy that she had an affair with. He was fine with her getting another job. That's a very human thing. Why would you be okay with her going back to work with the guy that she had an affair with? Now, he went into detective mode when he found out about the affair. That's a very human reaction. Very human. He was on the computer looking up Reddit and infidelity and getting some advice. It's not easy when your partner cheats on you. He's struggling with it. They're making some progress in January and February because counseling, she turns it not about the affair, but about other issues. But they're making progress. They're kind of heading in a good direction. They go on this hike. And it makes sense that at that hike, she brings up this issue. Again, not that I want to be with Miller, but hey, I got to travel for work. Okay, I got to travel for work. And this is a detail that you just can't make up, right? He says, then when they're fighting about it, she said, well, my mom can come with me to chaperone. He leaves her because they got into a fight, not because she's afraid of heights. She goes on all kinds of bungee jumping hikes all the time. He comes back and he's like, oh, you're still there. He described to you what happened. He's not saying, oh, he grabbed me and pulled me down. The scuffle started on this mountain trail and they ended up on the ground. Whether they tripped or fell, whatever, he ended up on her. And then he told you how she's grabbing his testicles. And she admits to it. And then I also squeezed his testicles. That's her testimony. It was all happening so fast. We spent a lot of time going through it all. That's not real life. In real life, you don't get hours to be like, okay, and then you did what? Well, why didn't you do this? Well, did you consider that? Did you consider doing this with the rock instead of... It was happening in seconds, and he reacted. And he had a reflex. And that's human. That's human. That's human. He reacted. And then he felt horrible about it. And he told you about that. He never wanted to hurt her. Never. He felt terrible about it. He was shocked that he could even do that to her in that moment. He felt horrible. The physical evidence supports his story. The DNA, and I'm going to get into the medical evidence a little more in a second. You have this, which apparently might have been dirt. Undeterred, might have been dirt. You have a cut, you have bruising. Right where he said he was hit. Reasonable doubt. Now, the FaceTime with Emil that they call a confession. There's no assurances of reliability. He explained to you what happened in that call. We need to consider it in the context in which it took place and ask ourselves, is this a reliable thing that happened that we can rely on? Two highly emotional participants in the phone call. One is suicidal. One is thinking his life is over. He's very emotional, calling his son to say goodbye. The other, obviously, not blaming Emil at all, incredibly emotional. His grandma said she was shaking, crying. Two very, very emotional people. Then you look at the environmental factors. He's on the side of a cliff. And they made it a point to get the HPD officer to say, it's very windy over there, notoriously windy. Very, very windy day, according to the police. He's on speakerphone on the side of a cliff, talking. And he told you what he did. He was explaining to her, look, she was having this affair, she got hurt, this is her blood, she crawled away or got away, she crawled away, and she said, I tried to kill her. He was telling her that's why he was going to end his life. He wasn't confessing. He was telling her, that's why I'm going to end his life. Now, we know this is his testimony. So as you sit here today, there's parts of the exact wording and timing of what was said that you don't quite remember exactly verbatim, word for word, correct? He said yes. He cannot tell us exactly word for word what was said. And then we have an example of him making assumptions. He first tells the detective, my dad said he tried to push her off the cliff. That's what he assumed. Not blaming him, that's what he assumed. But later on in the conversation, in the interview, the detective asked you about that, and he clarified, he said, the part about her pushing her off the cliff was what you assumed he meant, not what he actually said, correct? He said, oh yes, correct. So we have an example already of him saying something that he assumed that was inaccurate. He wants to say, it was so clear at the end of his redirect, he said, without a doubt, I know what was said. Do you recall how he had to try 4 times? The first 3? Emil said, yeah, I was confused. I'm kind of confused. And he asked again, yeah, I'm kind of confused. I'm kind of confused. And finally, Emil understood what the prosecutor wanted him to say and agreed. I'm not faulting Emil at all. Okay, this was a misunderstanding. The second call shows that. Gerhardt calls the second time, and he wasn't saying, why'd you rat me out? He was saying, wait, what? You told Ariel's parents I tried to kill her? Oh, like, I gotta go. And he was gonna go kill himself again. This idea that he wasn't giving Ariel to blow by blow what happened, Emil to blow by blow what happened, he was trying to say goodbye to his son. This is not a confession they're making it out to be. I just point out to you, it's not his fault. He's lived with Ariel the last year. He wants to be on Maui. He likes it here. He knows the only way he can stay here is living with her. We talked about her and her actions with the detective and the primary care doctor. He understood what the prosecutor wanted him to say after the 4th try. This was not a confession. Gerhardt's actions after the incident, they want to say it's consciousness of guilt. I say it's it's proof he's human. He went into deep despair. He couldn't believe that he could cause that kind of harm to the person that he loved. And that can coexist with defending himself in the moment, in that reaction. He felt horrible about it. He went into where he was suicidal. What he was saying to Emil on the phone was, I gotta go, I don't want the police to find me, is because he wanted to keep open the option of killing himself, which was turning to be harder than he thought. He didn't want to get caught at that time because he was still thinking about jumping and killing himself. He wasn't evading the police for the purpose of, I don't want to get caught. He wanted to be able to kill himself and have that option. And we'll talk about when he turned himself in later. And that's why he did what he did with the SIM card. He didn't want the police to find him because he was thinking about killing himself. And this idea that in the middle of this suicidal place of being super emotional, that you open your SIM card, you bend a paper clip, open it, and you're going to take the time to put it back where it was instead of just leave it over there. It shows he's human, that he felt terrible about this. He told you how bad he felt. And that can coexist with self-defense. Now, this idea that he was fleeing from the cops, first of all, the officer didn't say we pulled up right next to him. Very clearly they said we pulled up, there was a lane in between us, and he was on the grassy area. This grassy area right here. They said he was here when they got out of the car and he started to flee. And remember, And I said, come on, you know, how the heck was he not going to get in the bushes if that were the case? And then, shockingly, the prosecutor asks him, well, you played D1 football, right, officer? I mean, the fastest man in the world, Usain Bolt, Olympic sprinter from Jamaica, could not get to him from the car if he's trying to get into the bushes. Look, I get it. Officer safety. Look, I'm not faulting them. They came in hot. They're the strategic enforcement detail. Apparently, you got to be 300 pounds to be in it. I get it. They think he has a syringe. Okay? They come in hot. They couple strikes. Don't hit him in the face and arrest him. I'm not faulting them for that. I don't know about this, you know, saying he was trying to flee. Okay, that's not cool. Okay? But I get it. Officer safety. He has an injury. Look at this. It's dry blood and it's bruising. It's the kind of purple bruising that takes place hours later. When you first get an injury, it doesn't bruise. This happened earlier. Dry blood, purple bruising. That takes time to get to that point. A theory in search of facts. I talked to you guys about this. To try and use a computer to manufacture financial motive without telling us last week that sometimes, I'm sorry, how much time is that? Thank you. That sometimes the computer opens files and shows it was accessed. Don't you think that would have been fair to tell you guys that? Instead of leading you to believe that 100% Gerhardt looked at all of these things? Look, make no mistake, he said 80% of it he looked at. He's not hiding that. He's just, when he's up here saying, like, I don't remember at 3 a.m. looking at a 2018 Amex credit card statement that was in my old divorce file. And, you know, I mean, but undeterred. It shows he had a financial motive. He was looking up how much his divorce costed him in the past. What? He makes a lot of money as a doctor. The search terms: kill, push, shove, syringe. They're looking for the smoking gun. They have had it with his computer. Looking for the smoking gun. What do they find? No smoking gun. Just some search about hikes that you would search if you were truly just going on a hike. Again, maybe, maybe not. They were looking for the smoking gun. They don't find it, so what do? They manufacture a motive, undeterred, theory in search of facts. Oh, no smoking gun. But you know what? It shows he's looking at financial documents. He has a financial motive. It's not fair. I submit to you that whatever they found on that computer, they would find some way to spin it. Whatever they found, they would find some way to spin it. That's not fair. The work bag. And this, I gotta say, he uses these tools and materials to save lives. And they want to fault him for having it? He's a doctor. He talked to you about why he has it on Maui, not on Oahu. He uses these things to save lives, not try and somehow poison his wife. And she knew he would take it from work every day. Now, self-defense, first thing you got to decide is whether or not this was deadly force that he used. We know it wasn't. And we're going to get into that in a second. But it doesn't matter either way because it's the same rock that she hit him with. So even if it was, even if you say it was deadly force, it was the force that was used against him. So it doesn't matter. It's the same rock. The only thing it does say about it, and this is the part that was incomplete, about the duty to retreat. It says, the use of deadly force is not justifiable if the defendant knows he can avoid the necessity of using such force with complete safety by retreating. You only have to retreat if you can do so safely. She's holding on to his testicles, hitting him. And it just talks about being reasonable. He used the same force that she used against him. And they want to say, well, look at the difference. How could it be the same rock? Obviously, if one gets hit cleaner than the other, the same rock can do that. You know, like I could throw something at a baseball at someone's head, and one it hits them in the face, and one it hits them in the arm. It's going to cause you know. Obviously, it can be depending on how the direction, how hard the landing was. He stopped. He stopped. He didn't keep going. What amount of force was used? What amount of force was used? We know. Like I said earlier, we know what Ariel says she doesn't know. I don't know the exact number. They are downplaying what she said because they know it doesn't make sense. They're saying, oh, up to 10 times. So what does that mean? 6, 7, 8, 9? Doesn't mean 2. But now they know that doesn't make sense. She was hit 8, 9 times. And, oh, maybe she meant less. She doesn't know. Grosjean says possibly 2, maybe more, I cannot tell you. Arden says 2 to 3. He says 2. Grosjean talks about, oh, there's rock in there or dirt. He's not a forensic pathologist. He didn't test the material just to show like what it was. You know, her condition after. You saw her walking. She's walking on the hill. Okay. But more importantly, this is her talking after. And I'm going to ask you to do something with me now. If you could help me out here. Either close your eyes or don't look at the screen and just listen to her voice.
Where does he work?
He works for TMG at Maui Memorial Medical Center. TMG is called it.
At Maui Memorial.
Memorial, yeah. So what TMG is a group of anesthesiologists.
Did you guys drive here today?
Yeah.
Which is your car?
It's a Nissan Rogue.
Do you remember the license plate? If not, that's okay.
It's not our car, we live on Maui.
What color is it? The Nissan.
It's like black or it's gray. It's gray. Somebody just wet my mouth. Like a wet paper towel or something. My mouth feels really gross. I don't have any more here, so. Sorry, I know. No, you're an angel. Just trying to stop the bleeding until they get me. I know, I really. 24.
What was Gerhardt wearing today?
Wearing like a light gray shirt and
Okay. Does she sound like she has a traumatic brain injury to you? She sounds okay. Look, I'm not saying it wasn't a bad cut. And look, I'm not, you know, nobody wanted her to have that cut. I'm not saying it's not, you know, I'm just saying the level of force he used, you can see. It was, he talks about chunks missing from his scalp. No doctor said that. It was soft tissue. You heard from Dr. Arden, a very credible man, that apparently for 14 grand is going to sacrifice his integrity. Obviously, he's not going to do that. He told you the blood is not a good indication of the severity. The blood is not a good indication of severity. No skull fractures, no soft tissue. The tip of her thumb, he said, it was just the very tip. And sure, after the first hit, he puts her thumb, it hits, just the tip is fractured. We heard about that. All 3 doctors agree. No substantial risk of death and no serious bodily under the law. All 3 said that. We talked about the stellate laceration. The Glasgow coma score was 15 out of 15. Triage, they waited a few hours outside because she wasn't in that serious of a condition. She had a bad laceration. They sewed it up. She went home the next day. And I don't mean to. He feels terrible that happened. But he wasn't trying to kill her. That's about the amount of force that was used. Now, her eye. Let's look at this photo. The orbital is the most fragile area there is. And he said, very fragile bone. If he hit her with that rock, it would have broke bones. There was a scuffle. They landed on the ground. They're fighting. There's elbows. He's going for the rock. They're fighting for it. There's no doubt her eye got hurt in this thing. But he didn't smash her eye with the rock the way they want you to believe. And then you have his injuries. We talked about that. Now, it's the state's burden to prove to you this was in self-defense. More than probably. That it wasn't under the circumstances that he reacted as a human when she was doing these things to him and hit him. They have to prove to you it doesn't apply. It was a reflex, it was a reaction, it was a human reflex and reaction to defend himself in the moment. And that can coexist with him feeling terrible about it after. This happened extremely fast, and then he stopped. Now, we talked about the elements of attempted murder. He had no intent to kill her. You see on the bottom, and self-defense applies. They have to disprove those two, self-defense. Then there's something that takes you down to the others, right? The other offenses. If and only if you find the defendant not guilty of attempted murder, then or unable to reach a verdict, unanimous verdict, then you must consider these other included offenses. None of them apply. Self-defense is a defense to all of them. If you think that they didn't disprove self-defense, it goes all the way down. But you work your way down through these things. I'm just going to go through it quickly because I don't have a lot of time. The next one is attempted assault in the first degree. That he took a substantial step in conduct intended to culminate in the commission of assault in the first degree. That he intentionally or knowingly was trying to cause serious bodily injury. Let's look at the definition of serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. The doctors say she didn't have that. He wasn't trying to do that. This doesn't apply. Self-defense, no intent to cause serious bodily injury. You go on to assault in the second degree. Again, serious, no intent to cause serious bodily injury. Self-defense applies to all of this. So you work your way through, self-defense applies to all of it. Her motive to try and get custody and conviction of any of these things helps her with that.
And I do have
Assault in the
questions
third degree.
for improper instruction on the law.
Should be substantial.
Ladies and gentlemen, we have the instructions in the law. That's the instruction that you follow.
Then you get to assault in the third degree, bodily injury or negligent use of a dangerous instrument. Again, self-defense. He wasn't negligent. He was reacting. Reasonable doubt as to every one of these included offenses. So you just work your way down. And then there's something after that called a mutual affray. If this was a mutual affray. Reasonable doubt as to all of these. Now, I'm almost at the end here. I have couple more minutes. I want to end by saying a few things. This is the law. I ask you to use this as a guide to your deliberations. It's not about trying to figure out what happened. Your only goal is to answer the question, is there a reasonable doubt? Did they prove beyond a reasonable doubt this was not self-defense? More than possibly, more than probably. Let that guide your deliberations. It's a way to simplify things. After you talk about any piece of evidence, come back and remind each other, yeah, but does that prove this beyond a reasonable doubt? Let that guide your deliberations. I couldn't help but think last night. When they moved here to the United States, there's these constitutional rights that we all have. They didn't know it at the time, but it was for a moment just like this. When a jury of his peers would come together and follow the law and follow through on the oath that you took. I want to end with a quote. There was a politician back in the day who was giving a speech, and it was to other politicians, but I think it applies pretty well to jury service. says, "For those to whom much is given, much is required." And when at some future date the High Court of History sits in judgment on each of us, recording whether in our brief span of service we fulfilled our responsibilities to the state, our success or failure will be judged by the answer to 4 questions. First, were we truly men and women of courage? Second, were we truly men and women of judgment? Third, were we truly men and women of integrity? And finally, were we truly men and women of dedication? I ask you to keep those 4 things in mind as you deliberate. Courage to follow the law and do what's right, even if it may not be popular. Judgment to see through some of this ideas that he had a financial motive, that it was cheaper to kill her. Common sense judgment. Dedication to these principles and our Constitution. Dedication to it. Uncompromised dedication to the presumption of innocence and reasonable doubt. Deliberate that way. Uphold your oath. Follow the law. Let this guide you. Enforce the reasonable doubt standard. Follow the law. Do these things. And integrity will be yours. Thank you for your time over the last month. On behalf of Dr. Koning and Manta Dirks, thank you all for your time.
Appreciate it. Stacey, go ahead.
Mark Twain also said, "If you tell the truth, you don't have to remember anything." Think back to defendant's testimony. Think back to every time he was asked on cross-examination something that made him look bad, something that made him look like he had a motive, something that was incriminating. Think back to every single time the defendant was asked something like that. And what was his answer? "I don't recall." Ariel Koenig was able to sit here and testify in front of you for 3 reasons. First, she had her intuition. She saw the defendant looking at her feet on that trail. She saw the defendant tracking her every move. She saw the defendant making sure he saw where she was. And that's what made her feel uneasy. It was her intuition. Second, she fought back. She fought for her life that day. And defense wanted to characterize it as a full conversation, but it was Ariel begging for her life from the defendant. It was Ariel saying, "Think about the kids." It was Ariel saying, "Nobody's going to believe this was an accident." This is Ariel trying to reason with somebody who is trying to kill. And the third reason, and the most important reason that Ariel was here to testify to you, is Amanda Morris and Sarah Buxbaum hearing a call for help, going forward, looking at what they saw, and helping Ariel out. Because the evidence shows that is the only thing that stopped the defendant that day. The only thing that stopped him from continuing to beat Ariel with that rock, from continuing to hit her, from continuing to try and kill her, was Amanda Morris and Sarah Buxbaum catching him in the act. Defense wants you to think about the life insurance. But you should think about it differently. This is a couple who's going through it in their marriage. Why is it time to renew life insurance? Does that make any sense? No. What the life insurance is, what many of defendant's actions are, is the defendant covering his tracks. The cover-up proves the crime. Defendant had control of the scene when he was done, so he took the evidence with him. He didn't need to take the rock. In fact, he knew that he was seen with the rock. He knew that Amanda and Sarah saw him with the rock. Why take it? And what reason would Ariel have to make up the syringe? None. Think about what Ariel knew. Ariel knew that he had tried to push her. Ariel knew they were right next to a cliff. Ariel knew that people walked up as she was being beaten with that rock. She had enough already. There's no reason to make up the syringe. Defendant's attorney said something. These are the facts you just can't make up. And that's what the syringe is in this case. It's a fact you just can't make up. Let's talk about the confession. Emil told you he has no doubt about what the defendant told him. If this was truly a goodbye phone call, if this was truly the defendant telling his son that he was going to commit suicide, what purpose at all would there be to accuse Ariel of having an affair? What purpose does that serve in saying goodbye? That makes no sense. It's just trying to throw dirt on Ariel. That's all it is. It's trying to throw dirt on her. It's trying to make her look bad. It's trying to justify his actions because he knew from the minute he did it, and he knew from the minute he planned it, that it was wrong. And then look at that timeline again. Why? It makes no sense. The defendant was simply trying to say goodbye. It was simply a miscommunication between himself and Emil. If it was a miscommunication, why wasn't it cleared up? Why wouldn't he just tell Emil in that second phone call? Why would in neither of the FaceTime calls the defendant say anything about self-defense? Why wouldn't the defendant say anything about Ariel supposedly attacking him? Because in that moment, he was confessing. In that moment, he had a guilty conscience. And that's why he did what he did. That's why he hid. That's why he tried to run from the police. Think about the list of people that would have to participate in this, what essentially is being alleged as a massive conspiracy to believe what defendant's saying. You have to disbelieve Ariel. You have to disbelieve Emil. You have to disbelieve Amanda. You have to disbelieve Sarah. You have to disbelieve the medical evidence. You have to disbelieve the doctor that the defense hired. And you have to disbelieve what you saw with your own eyes. That's why the defense asked you to close your eyes when they played that video. They wanted you to ignore what you see. That's what this case is about. That's what they're asking you to do. Open your eyes, make a decision based only on the evidence, and the decision is clear. The defendant tried to kill her. The defendant tried 3 different ways, and he learned out multiple times that day. It is harder to kill than you may imagine. You were told earlier about the defendant's constitutional rights and the founding of this country and how important that is. What are those three phrases that this country was founded on? You've probably heard them before. Life, liberty, the pursuit of happiness. And in this case, the defendant, beyond a reasonable doubt, made a conscious choice to try and take Ariel's life. He made a conscious choice to kill her. And that is why the only verdict that is supported by the evidence is that the defendant is guilty as charged. Thank you.
Thank you, Mr. Brennan. Just about ready to send the jury in for deliberation. Before I do, to the first 12 jurors, is there anybody here who feels for any reason they cannot participate in deliberations in this case? I see no hands. So that means Mr. Kiyama, Ms. Kishi, Ms. Pang, and Ms. Yang, I'm able to let you go, but you're not quite yet done. If one of the other jurors cannot complete deliberations, you may get a call to come back and participate in deliberations. Okay. So, even though you get to go back to your regular lives, and you're not sitting here in the courtroom, those 3 rules still apply. Don't talk to anybody about this case. Keep an open mind. Do not try to learn about this case outside of the courtroom until one of 2 things happens. Number 1, you get a call to come back. Or number 2, you get a call letting you know that deliberations are complete and the case is done. So unless or until you get one of those 2 calls, those 3 rules apply. Don't watch any media, just in case you might have to come back and do further jury service. On behalf of the parties and the rest of the judiciary, thank you very much for your time and your service. I talked about Gold Star jurors early on. You're weathering 2 storms to be here, and all the flexibility and perseverance that all of you showed. That still remains true today as more storms come our way. So again, thank you very much for your dedication, your perseverance, and your service. If I do not have a chance to talk with you later on, I hope you and your families remain safe during this upcoming storm. And again, you have our gratitude. Thank you very much for your service. You're free to leave the courtroom. Thank you. Everybody can be seated. So ladies and gentlemen of the jury, as you already know, lunch is going to be brought in for you while you're in the jury deliberation room. I do have a couple of final instructions before I send you in. Your deliberations take place during what I call banker's hours. So you're allowed to deliberate up until 3:45 today. If you're unable to reach a verdict, I ask you to come back, start again at 9 o'clock. And the reason why if you ask why is it so early, because if there is a verdict, there is time needed to assemble everybody to receive the verdict, and it won't happen before the end of the day. So that's why I release jurors at 3:45. Have you come back at 9 o'clock if you don't reach a verdict today. You will have communication forms along with the verdict forms that will go into the jury deliberation room along with the exhibits. One note about the communication forms. If you do send the communication to the court asking a question, it does take some time before an answer can come back to you. Sometimes it takes up to 45 minutes, sometimes an hour. If you're waiting for a response, if you can continue on with the deliberations, please do so. A couple of other things. You will not have the opportunity to ask for any additional information that you think is helpful. So you have all of the evidence that's available to make your decision on this case. Also, there are no transcripts available for the testimony of the witnesses. So you have to rely on your collective recollection as to what the testimony may have been. Before I send you in, is McCallum, Ms. Alvin Fisher. Will you stand and raise your right hand? Do both of you solemnly swear or affirm that you will take this jury in charge, that you will not communicate with them, except by order of this court, that you allow no one to communicate with them, and that you conduct them into court again whenever so requested by them or by order of the court.
I will. I will.
Thank you. So, ladies and gentlemen, I'm going to ask that you take your notebooks, take your jury instruction packets, and all your personal effects as you go into the jury deliberation. All rise. Everyone can be seated. Jury is out of the courtroom. Mr. Garner, anything you want to place on the record before we recess?
Nothing from the state, Your Honor.
Mr. Otake, anything you want to place on record before we recess?
No, Your Honor.
To all of you, thank you very much for the work that you put in this case. I remain impressed by the lawyering talents. I haven't been here that long, maybe it's long for some people, but one of the true joys of this job is watching excellent attorneys represent their clients and apply their craft. And I am truly privileged to watch that in this case. So thank you very much for excellent lawyering. Until we hear from the jury, court will be in recess.
Thank you, Your Honor.
You are muted.
Yes, I have seen Five Nights at Freddy. I like the first one too, and I'm glad that they're making a second one. I thought it was a very good movie. Yes, yes, I hear what you're saying. Absolutely. I look forward to seeing that. Oh, it's on Peacock. Okay. Yeah, it's because it says it comes out in December of this year, so maybe they had an early release. I've not seen it yet, but I look forward to seeing that. Yeah, it was released on Peacock. Yeah, on April 5th. Oh, okay. I'm getting myself a little bit mixed up here. So it originally came out last year in December. So it was 2025. I got I was not realizing it came out last year, December 5th. And yeah, I didn't realize that. I would have seen it. I must have been kind of busy or something around that time. I would have seen it, but yeah, Saw Girl. I will watch it and tell you what I think of it. Well, we'll talk about it on the show, all right? Or maybe on one of the Garden streams or this stream. Yeah, I saw the first one. I saw the first one. I thought it was good. Oh, Miss C, what was that then? Yes, Falcon. God is the only final judge. That is true. Abby One and I talked about the different like conspiracy theories and lore behind the franchise a couple of streams ago. I mean, last year at some point. It was pretty fun. All right. Sawgirl says, "I agree, and this is only one who." Oh wait, yes, amen. But how long do you think the jury will be out? Anybody want to take a guess? I think, my opinion, I'm a bit in the dark. I'm going to give a guess. I think it's not as. It could come back soon with a guilty verdict, or maybe they'll come back with an innocent verdict, or something in between. We will see what the jury does. I think they may take an hour at least, and it could be longer, possibly, or a couple of days, but I think the jury will find a quick verdict if it's guilty or not guilty. Maybe, I think that they came back less than an hour, I'd be surprised. Okay, Miss C says 2 or 3 days. Okay. Yeah, definitely not quick. I agree with that. Yeah, he did very good on the stand. Yes. Let's see. Now let's do this again. "16 jurors. And on the panel, it consists of 12 primary jurors and 4 alternatives. 11 women and 5 men. Yeah, I don't really know what you're talking about. Yeah, I'm not too sure either, Saw Girl. I've seen so many of them, I don't even quite recall myself which one it was. But yeah, I know what you're talking about. It was like, you don't expect if they'll come like 3 hours later with a different verdict. Missy says she thinks you'll get a assault charge. Saw Girl says, yeah, I think they do come back with anything. It'll be with a lesser charge. It sounds like a domestic situation gone way wrong. Yeah. It definitely, we'll see how the jury thinks it will go. Definitely may be the case. They still go over evidence. Yeah, there's lots of evidence to go through. There's lots of deliberations. That's a process in itself that doesn't take very quickly. There's also that factor. Oh, 12 jurors will take longer. Okay. Okay. Yeah. Could be a couple of days. Ah, okay. Okay. He didn't any attitude though. Yeah. He definitely, it depends. When he's sitting down watching the different people. He looks kind of like has a menacing look, but when he was on the stand, he seemed pretty chill. Oh, I would think it does, Falcon. And we watch these trials all the time, and definitely in agreement with you. Yeah. Scared. Oh, Falcon, glad, amen. Glad they dismissed the case. Amen. Oh, whoa. Sawgirl says got arrested once for she was drinking in home and house guests that arrested, and she was so pissed. You don't do that to somebody first and only time I've ever been arrested last year. Oh, Sawgirl, that is completely cringe, especially if you're in your own home. That has to be extremely like the most annoying, cringiest thing ever to have to go through something like that. Yeah. All right, so let's see here. We'll look over something. All right, so we're going to talk about some Five Nights at Freddy some cryptic lore about it. The movie that Sawgro and I were talking about. So, here we go. Classic and debunked theories. Nathan Dunlap murders Perlo. An early game theory suggested that the first game was based on a real-life shooting at a Chuck E. Cheese in 1993. While the dates and locations had eerie similarities, this was never confirmed and is now viewed as more of a coincidence than intentional lore. Foxy is a good guy. A long-running fan theory claimed that Foxy wasn't trying to jump scare you, but was actually running to the office to check on you, and his scream was just his voice box malfunctioning. This has been largely debunked, as Foxy still causes game over like every other animatronic. Bone Guy is a purple guy before identity of William Afton was fully established. Many believe Bone Guy, who guides you, was actually the killer. This was eventually disproven when FNAF 3 and subsequent lore showed their distinct fates. Understood, Missy. Dream theory. After FNAF 4, a massive theory suggested that the entire series was just the nightmare of a dying child. While it fits many clues at the same time, Scott Cawthon later implied that the story had changed or evolved past this. The community continues to debate. Yeah. There's a video game first. All right. So at first it was a video game, which it's still there today. But like, it's the same thing as the movie, but it's the game version of it, which it's linked to the movie itself. So this kind of gives you some more details than the movie, because it's part of the video game. Oh, you're welcome. You're welcome. All right, the major unsolved mysteries. The Bite of 87. While the Bite of 83 was shown in FNAF 4, original Bite of 87 mentioned in the first game is still debated. Top candidates for the culprit include Mangle, Withered, Chica, and Toy Bonnie. Who is the one you should have not killed? In the Ultimate Custom Night, a vengeful spirit haunts the William Afron. Fans are split on whether the spirit is Cassidy, a character that Andrew from Fazbear Frights books. Yes, yes, a Mario Brothers. That's a game that I played coming up, and that game was very good. It was extremely interesting to see because I played the Mario games and I saw some Mario cartoons, but seeing it into a movie now and before was awesome. Midnight Motorist Identity. The Midnight Motorist minigame of FNAF 6 features a yellow man driving home. Theories range from him being William Afton during a rainy night to him being a completely different character. All right, urban legends and hoaxes. Sparky the dog. A leaked screenshot once claimed a secret dog animatronic appeared in the backstage room of the first game. It was later revealed to be a high quality Photoshop job. Purple guy in the kitchen. Early rumors claim that if you performed specific actions, you could see the purple guy on disabled kitchen camera. There are no files in the game for kitchen confirming this was a total myth. Yeah, scared. All right, so modern game theories post security breach. Okay, I am back. I am back. Was going to bring this back up. Let's see. Right here. Okay. Bring everything back. All right. All right, so I have returned. It went out for a moment, but I'm back now. So let's do that. Yes, that's Judge Ito from the OJ trial. Yeah. Okay. So let's just do this again. All right. Oh, okay. Thank you for stopping by. I appreciate it. Oh, so actually, Moki was the one that suggested the Judge Ito emoji. So, perhaps that may be the case. Thank you, Carlos, for the nice dono. I appreciate it. Yes, that's the same one, the one from the Ito case. Uh, Ito, yes. Yeah, the we're talking about Judge Ito's emoji. She was wondering if you like him too. Yes, he is still alive. All right, so so I might repeat something, but we're going to go over the Five Nights at Freddy video game conspiracy theories. Okay. Oh, we saw it yesterday. It was like light and it went dark. Yeah. Yeah. Yes, caught. It went dark. All right, the missing children incident. The belief that 5 children were lured into the back room in June 26, 1985, murdered and stuffed into the animatronic suits by William Efron. Yes, Carlos, definitely. Head out, peace, Middle East. Yes. Shout out to you. All right, so bites. A long-standing debate on which incident occurred, FNAF, most now agree that Bite of 83 involved the crying child, while the Bite of 87 mentioned the first game happened in different locations. Remnant of Agony. These are the pseudoscientific explanations for the possession. Yes, Carlos, we'll look forward to seeing you there. Absolutely. Remnant in the soul energy extract for the experiment, while agony in the raw force can animate objects. Gregory and a robot. A popular theory from the security breach suggests that the protagonist, Gregory, is a robot recreation crying child supported by the glitch version The Mimic. A major shift in recent lore suggests that the current villain isn't actually Williams Afton's ghost, but a sophisticated AI program designed to mimic him. Dream theory. An early, most discredited theory is that the first games were all just nightmares of a dying child. Flash MPREG incident. One of the most famous stories in the books involved developer giving birth to a small spring trap, leading to many bizarre community theories about physical nature of Fazbear entities. Sparky the dog. An early hoax claimed the secret dog animatronic appeared in the first game's backstory area. Phone guy. A purple guy. A theory early days that suggested that hopeful guide of the phone was secretly the killer. Yes, Falcon. I remember that one. I saw that scene. All right, Lori, understood. Thank you. All right, what's this? Yeah, scared. All right. The Sparky Dog. An early hoax claimed that the secret dog animatronic appeared in the first games. A backstage area. The phone guy, purple guy. Okay, we talked about that. Let's see about some more. Ah, okay, Mohi. Understood. The phone guy's true identity. Oh, I appreciate it. Thank you. Saw girl. I appreciate it. Phone guy's true identity. A long mystery in the books revealed that the guy's name, Ralph, he worked as Freddy to support the daughter, Calypia. And hides evidence and may be attacked by multiple electronics simultaneously. Shadow entities. The theory suggests that Shadow Freddy and Shadow Bonnie aren't ghosts but entities made of dark remnants of pure negative emotions. Shadow Freddy specifically may have been a trap set by William Afton to lure children to their deaths. Jeremy is Bonnie. A growing theory from recent lore suggests that the spirit inhabiting Bonnie as a child creates a tragic parallel with Jimmy Fitzgerald. Too many have been victim of Bite of 87. Mimic and pre-80s origins. 1979 origins teasers of Secret Mimic revealed that 1979 pushed for the timeline back to earlier and before. It suggested that Mimic AI has been around since the 70s, potentially mimicking Afton's crime for decades. Mimic in Burn Trap. Most of the top theories now suggest that Burn Trap and Security Breach isn't Afton's physical corpse, but a Mimic AI wearing a discarded suit mimicking Afton's behavior. The kitchen camera. Early rumors claim setting the F&F custom night on quadruple 6 would unlock the video feed for the kitchen. In reality, the kitchen was only ever an audio location to save the game's memory. Oh, it takes a minute. I see. Purple Guy is Phone Guy. Hoax fans once pointed to the badge Purple Guy wears mini games as proof that he was a security guard. Was debunked when the books and later games became confirmed they are separate people. Sparky the dog. One of the most famous early hoaxes involved fake screenshots of a dog animatronic. The backstage area of the first game, it was popular that fans still reference him to newer titles. It's a low dose of radiation. Oh yeah, that's definitely serious indeed. Definitely. Movie and gameplay lore. Alright. Mike Schmidt's identity. The game Mike is all confirmed as Michael Afton in the movie. He is a separate person whose brother Gerhardt was the one taken by Afton. Vanessa. The movie Shocker revealed that Vanessa, Afton's daughter, where the game Security Breach, she is secretly a guard manipulated by the AI virus. All right, talking about the core premise of the game is the original games you play at night, security guard, working at 12 a.m. to 6 a.m. shift on Freddy's Fazbear's. Yes, the verdict clock. Yeah. The problem, the restaurant's mascot animatronics, Freddy, Bonnie, and Chica, and Foxy, are allowed to wander at night to prevent their motors from locking up. However, they are hostile, attempted to stuff you in a spare animatronic suit, which is fatal. Yeah, they brought batteries. Yeah. Yes, Love Earth. Yes, Love Earth. Yes, yes, it's a lot like the movie. Gameplay: you are confronted to an office. You're confined to an office and must use security cameras to track their movements to survive. You must manage a limited power supply to close security doors and turn hallway lights on to get close. While you look into the simple horror game, the Easter eggs and hidden minigame reveal dark history. Tragedy: years ago, the co-founder of the restaurant, William Afton, murdered 5 children, hiding their bodies inside the animatronic suits. Possession: guided by an unknown entity, is the puppet possessed daughter of Afton's business partner. The spirit of these children now inhabit robots that aren't just malfunctioning; they're seeking revenge against Afton, often mistaken an adult guard for the killer. Family: a cycle. Much like the series follows Afton's son Michael as he tries to undo his father's horrific legacy across different haunted locations. Early prequels, sequels. Games like NFAF 2 and NAF 3 expand the lore of Springlock suits and Afton's eventual death and rebirth. I don't think I have Falcon, but I'll look into it. Modern era. The titles like Security Breach features massive mall called the Pizza Box in the Pizzaplex, where you play as a child named Gregory who must escape the free roaming animatronics. Oh, yeah, and Miss C, definitely that is, unfortunate with the inflation and food prices and all that stuff. I definitely, yeah, men see it as starving. That is an interesting way to look at it as a way of dieting. But yeah, definitely it must go down. Indeed. I mean, the prices must go down at some point. Oh, okay, Falcon. Interesting. Interesting. Okay, sorcerer trying his pupil. Okay. Falcon says he usually has 1 meal a day. Interesting. Used to I going back and helps weight control. Oh, okay. Sargos says my daughter is dragging me off to the grocery store. I'll be listening on the phone, and I'll see you. You hopefully don't have a verdict until I come back, or do they go home? Oh, they will. Yeah, we will see. I'll let y'all know if there's a verdict or something going on. All right. They probably will be going home tonight, but yeah, definitely be listening. Yes, Lori, the jury is deliberating. The jury is deliberating right now. All right, so possession of animatronics. While there are dozens of characters, these are confirmed identities of the spirits trapped inside the main suits. Moki says it's almost 2 a.m. there. It's almost 2 p.m. there. My fault. It's almost 2 p.m. there. I don't think they'll have a verdict today. Okay, thank you, Moki. All right. Freddy Fazbear, Gabriel, possessed by Gabriel. Bonnie the Bunny, possessed by Jeremy. Chica the Chicken, possessed by Susie, the first victim of the group. Foxy, the Pirate Fox, possessed by Fritz. Golden Freddy, often believed to hold two souls, Cassidy and vengeful spirits. and crying child, William Afton's youngest son. And okay, let's see, go 3 to 4 5 their time. Yes. We won't need all the drawn out court hearings if we were all telepathic. Yes. Yes, if we were telepathic, it would certainly solve a lot of issues. Absolutely. The puppet, possessed by Charlotte, or Charlie, Emily, the daughter of the restaurant's co founder, Henry. She is the one who gave life to others by suffering, by stuffing them into the suits. Springtrap. This is not just a ghost. This is physical rotting corpse. The leader killer, William Afton, fused to a spring lock suit after malfunctions and crushed him. Circus Baby, possessed by Elizabeth Afton, William's daughter, after she accidentally scooped by the machine of her father built. Shout out to all of you, are really cool people. Thanks for being here. All right. Mechanic, security monitor. How it works. Viewing camera feeds through the building. Tracking. Animatronic movement and freezing specific ones like Foxy or Freddy by watching them. Limited power percentage. Percentage bar drains consistently fast as you use tools. And it forces you to choose between safety, closing, and information checking cameras. Hallway lights. Buttons that illuminate the building spots. Outside your doors. Checking if Bonnie or Chica are right outside your office before you waste power closing the door. Security doors. Heavy steel doors that can be shut to block intruders. Your only physical defense in the later games, this is replaced by Mask of FNAF 2 or Audio Lures FNAF 3. I do not know what Culver's is. That's interesting. Security doors. Heavy steel doors can be shut or blocked. Intruders. Your only physical defense in later games. This is replaced by FNAF audio lures, spring locks. Minigames lore. Gears that hold animatronic parts back so a human can wear the suit. If these fail due to moisture or sudden movement, where the wearer is crushed instantly. In recent games like the Scrutiny Breach, the Security Breach, the mechanics shift from stationary office to first-person stealth. You play as Gregory moving through a massive mall hiding bins using flashlight and commanding a friendly Galmoric Freddy to navigate dangerous areas. Let's see. Will-eye sander, a popular North American freshwater fish named for its large, aqueous, and highly reflective eyes. And she's never had it. Yeah, I've never had it either. Yeah, now it's at 67. Scared. Oh, hilarious, Aaron. Hilarious. Oh, it's popular in the Midwest. Yeah, I would never heard of it here. Cod. All right, the Afton family timeline. Oh, I like salmon. I've eaten that quite often. And you like trout too. Interesting. 1983, the first casualties. Elizabeth Afton William builds the Funtime animatronic to kidnap kids. Despite his warnings, Elizabeth gets too close to the circus baby, who scoops and kills her. The crying child, Evan Cece, at Fredbear's family diner. His oldest brother, Michael, and friends put Fredbear's mouth as a prank. No, they put him in Fredbear's mouth as a prank. An automatronic, the mouth snaps shut, and bites to 83. The bites of 83 eventually killing him. Oh, base in Georgia. Nice. Catfish, Mississippi. Yeah. Deep fried fish cod is fire. Yeah, facts. Definitely. All right, let's see. Middle of the years. Michael's Quest. Circus Baby's Rentals. Williams sends Michael to find Elizabeth. Michael is scooped by Enard's fusion fun times and used as Sunkissed suit. He dies but is remained remnant by remnant vowing to find his father. The Pizzeria, 1987, 1993. Michael often used the Alice. The Mike Schmidt works for various pizzerias to find William on the free spirits. All right. Circles and baby rentals. William sends Michael to find Elizabeth. Michael is scooped by Enard. Hot smoke Atlantic salmon is good. Oh, yeah, definitely. Michael sends Michael to find Elizabeth. Michael is scooped up by Enard and use the sun suit. He dies, but remnant vowing to find his father. Oh, so Miss C, the South still has better fishing places than the Midwest. I see. Yeah, barbecue ribs is nice too. Jerky in Blitzhong. I've not had Blitzhong before. I have to look that up. All right, pizzeria. Michael, often using the Alice of Mike Schmidt, works for various pizzerias and finds William's free spirits. Printich. All you can eat fish, old days in South. Facts. Well, that sounds like it was a delicious place, Missy. Spring lock failure. William returns to an old pizzeria to destroy the evidence. Cornered by ghosts of his victims, he hides in Spring Bonnie suit and spring locks, Phil crushing him and turning into Springtrap. Fire 2023. Michael, Henry, Emily, William, all remaining Aftons are lured to a fake pizzeria. Henry sets building on fire, seamlessly burning everyone to ash and freeing the souls. Oh, okay, that's really cool, Falcon. That's cool. Yeah, I figured it was from somewhere else. I'll be RB. Be right back. Yeah, miso soup is very good. Definitely. Yeah, so miso soup is very good, and it was eaten for thousands of years in Japan. And and also the sushi. Uh, their culture, they really had high values of nutrition for many centuries, and they still do now. Lori says our local grass-fed beef is so good. That is good, Lori. That's excellent. Oh, really, Falcon? I'm sure you can. I'm sure you can. Yeah, I. Oh, and it's Amoki said it's very hot. Where I am, it's 70 degrees, but it feels pretty cool. Feels pretty cool. All right, let's see. Okay, and going to this next part here. Let's see. Okay, so mentioning cod. Cod is a highly prized, mild flavor and flaky texture, making a versatile staple in global cuisines. Because it takes well to preservation, it is often found in both fresh and salt cured forms, leading to increasing incredibly wide variety of dishes. And yeah, shout out to Tasmania. Nice to have Tasmania with us. And fish and chips, a British dish where cod is dipped in a light beer or water, base batter and deep fried. Fish cakes. Fritters cod is often flaked and mixed with mashed potatoes dough before fried. There's traditional Portuguese cod. Yeah, noise. Yes, yes, noise. And traditional Portuguese cod fritters made with mashed potatoes, cod, and onions. Puerto Rico style codfish fritters known for their thin, crispy textures. Fish tacos. Flaky cod is frequently used. Base of tacos either breaded with panko and fried, blanked with Cajun spices. I have a yummy pork shoulder with crock pot, and we are having pulled pork tacos tonight. Oh, delicious, delicious. Lemon garlic, baked cod. Filters are typically seasoned with lemon butter and garlic. Yeah, let's research from Tasmania. Fact. All right, let's go into the land of Tasmania. Yeah, we have some new people from New Zealand and Tasmania on this from on the ship. Yeah, we've had these intellectual conversations about UFOs, UAPs, and cryptids and stuff on the phone lives, and yeah, really cool. Yeah, and we talked about different things that exist in Tasmania and New Zealand, like Omoki. So in New Zealand, there's those stories of giants similar to the giant of Kandahar over there. Oh yeah, it's very beautiful. Yeah, very beautiful. All right, no fish, tacos, or shrimp gifts for me. All right. Oh, there's no Taco Bell there. Interesting. Taco Bell imperialism. Tasmania is Australia's only island state located approximately 240 kilometers, 150 miles south of the mainland. Known as a Tassie or Island. Apple Island. It's celebrated for having the cleanest air in the world, monitored by Cape Grim baseline air pollution stations. Oh yeah, I've seen like the Tasmania parts of it from the like Discovery Channel or something, and it looks very nice and uh because I obviously with my garden I like nature and stuff, so I like how their nature is cool. All right, the pristine wilderness. Roughly 42% of the state is protected in national parks, World Heritage sites. The UNESCO significance. The Tasmania Wilderness World Heritage Area means that 7 out of 10 criteria, a feat matched only by Mount Taishan in China, oldest life forms. It is home to the Huon pine, which can live for over 3,000 years, and self-cloning in King's Holly, estimated to be over 43,000 years old. We are so multicultural. It's hard to pick a national dish. Probably meat pies or mutant birds or mutant bird. Oh, I'm being teamy right now. Okay, mutant bird, which I'm not too sure what that is exactly. But thank you, because I'm not familiar with the dish. Thank you. Yeah, meat pie. Yeah. Unique wildlife. The Tasmanian devil. This is the world's largest surviving carnivorous marsupial and found in Tasmania. It has the strongest bite for size of any mammal in the world. Oh, you ate 6 at one time. Oh, that's cool. The thylacine, formerly the top predator, the Tasmanian tiger, was declared extinct in 1936. Monotremes is one of the best places to see the platypus Echidia, world's only egg-laying mammals. History and culture. The First Nations Aboriginal people have lived on the island for at least 42,000 years. All right, Falcon says Newton bird is a bird that the Aboriginal people have hunted for thousands of years. It is delicious for me, but not everyone likes it. Fascinating. Steak and kidney, yes. Oh, thank you, Falcon. It's very interesting. All right, Colonial Past. Originally named Van Diemen's Land in 1642, it was renamed Tasmania in 1856 to distance itself from history as brutal British penal colony. Okay. Lori says alien is pronounced like the word mutt. Oh, thanks. Mutton. I'm saying mutant bird. You see, it wasn't for chat. I'd crash this spaceship so quickly. So, thank you. It's mutton bird. Bird. All right. And the city's capital of Hobart, founded in 1804. Okay. Oh, it's lamb. Okay. For us. Okay. Lori said, I pretty much love what I should not be eating. I was never a casserole person. I know casseroles can have a unique taste to it, let's just say. It can have a unique taste to it. But it certainly, I don't mind them, but definitely it has a unique taste. Tasmania, the mutton bird is a common name for the short-tailed shearwater bird that is incredibly hardy seabird known for its epic migrations to the local Aboriginal Palawa people, known as the Yola moonbird. The scallop eye. Interesting. Yeah, hilariously. Okay, the scallop dish. Okay, interesting. Coined by early European settlers who harvested the birds for food, they noted that the meat, which is quite fatty, it tasted like sheep. Early officers even jokingly referred to them as flying sheep. Let's see. Okay, the Tasmanian scallop pie is regional culinary icon and a must-try for visitors to the island state. It consists of fresh Tasmanian scallops, 5 to 6 per pie, complete with their orange roe or roux, something like that, smooth and smothered in mild curry spice. I'm gonna get this right. Mild curry sauce and encased in flaky puff pastry shell. Moki wants to know what kind of animals do they have in Tasmania. And unique flavor. The defining characteristic is use of Ken's curry powder, Tasmanian-made product invented in the 1850s that gives the pies their distinctive, mild, slightly sweet tang. Key ingredients. While modern variations exist, the traditional filling typically includes scallops, curry sauce, sometimes diced vegetables like carrots, celery, and potatoes. A cultural status. Once a staple pubgoers, dock workers in 19th century, it is now considered Tasmania's national dish. Yes, a Tasmanian devil is one of their most notorious marsupials that the carnivorous marsupials, that's what it's known for. Definitely. We see that in our cartoons here a lot, the Tasmanian devil. So, yeah, that's something they're known for. Now, of course, there's other ones too. All right. Falcon says that there are lots of wallaby. We don't have crows, but we do have forest ravens, wedge-tail eagles, and hawk that is pure white, lots more. Wombats, quails. Very interesting, Falcon. Thank you for letting us know. Well, telling us, answering the question I meant to say. Yeah, because I was curious myself what's there. Really cool. All right. Jackman and McRoss, located in historic Battery Point. They are famous for a sophisticated versions featuring the scallops and Wakam no wa kami in a flaky pastry. Okay, and Smith's peas, Cambridge Selminnuka. Often credited as the original inventors, their pies are jam-packed with scallops, are featured in the Salem Manica market every Saturday. Ross Bakery, famous for its traditional wood fired ovens, operated since 1901, and providing the inspiration for the anime Kiki's delivery service. All right, that's really cool. Moki says, I live in the desert. We have rattlesnakes, scorpions, coyotes, wild horses, and burros. Probably said that wrong. It might be bureaus, something like that. And we have quail too. Oh, the desert is very fascinating. And those are, some of the Wild West's creatures. Falcon said, I have lived in the Australian desert. I love the desert, but the flies are dreadful. I could imagine I've heard that in deserts the flies are not good. Yeah. Now in Australia, I know there are deserts where there's lots of camels there, and the camels are plentiful because they use them to map out Australia, and then there was no natural predators, so they just kept on populating. So that's something I learned recently. Mogi said we have desert tortoises, which are cool. I've never heard of a desert tortoise. That's interesting. And Falcon says, I meant to say they Huel. They are like little cat dog like creatures, very cute. Oh, nice. Nice. Aaron says to Moki, uh, I should send you the pic of my uncle. The pic my uncle took. His dog deleted a bobcat protecting their chickens. Scared. Oh, Falcon said the only big predator we have here is humans and crocodiles. Ah, okay. Besides that, it's pretty much peaceful. Gotcha. Oh, Moki said poor bobcat was looking for a snack. Scared. Okay. Eastern Huol. This cat-sized spotted predator is extinct in the wild, but in mainland on the mainland, and is now found only in Tasmania. So it's an extinct species, but it only exists in Tasmania. Oh, yeah, I can imagine lots of snakes and spiders. Yeah. All right. Tasmanian wombat, a slightly smaller and shaggier subspecies in the mainland common wombat, frequently seen grazing in open grasslands at Cradle Mountain. Tasmanian patamelon, a small, stocky relative to the kangaroo with a reddish belly, abundant across the island, found nowhere else. Aaron said, we don't have much on our island. Our biggest predator is a coyote. In Canada, we have bears, etc. Oh, yeah. One of my friends in Canada has polar bears. So there's those allegedly are there too. Oh, Aaron said yes, unfortunately. But because they asked her, do you say eh? They do say that. Forest kangaroo, the largest marsupial in Tasmania. It is subspecies of eastern grey kangaroo that can only reach about 6 feet in height. Aaron says we say yeah no a lot too. You know a lot too. Mana Tremes egg-laying mammals. Tasmania offers some of the best opportunities in Australia to see the world's only two egg-laying mammals. Platypus. Tasmania's platypuses are notably larger than those on the mainland and are more active during the day in certain areas. Yeah, yeah, Aaron, I figured you meant that it was yeah, no, like yeah, nope, like that kind of no. But thank you for clarifying. And she said, "Don't ask." Oh, scared. There's the each idna, the spiny anter. The Tasmanian subspecies, typically the thicker fur than mainland populations, have cooler climate. They lay eggs. We got raccoons, groundhogs, cardinals, and yellowbirds, lots of butterflies. Oh, that's very cool. Missy. Let's see. Oh, she says they say you're okay, and she says it too. Yes, correct, Falcon. Yeah, I was just looking at that. The Yeah, that is very cool. They lay eggs. Yeah, it's something we wouldn't really see with the creatures here. Believe Mississippi, don't say you're okay. Okay. Believe you're not okay. Right. All right. So the desert tortoise, a resilient land-dwelling reptile, that has inhabited the southwestern United States and Mexico for at least 15 million years. Recognized as the official state reptile of both California and Nevada, it is considered a keystone species because its massive underground burrows provide shelter for dozens of other desert animals. Aaron said, I got a robin building a nest at my back door and geese claiming my backyard. Only a matter of time before the swans are back. Then my chicks. I'll be surrounded by birds squeaking. No, not squeaking, but squawking at me every morning. It'll be like the Bird Island. Aaron's going to wake up in the morning and see all these different types of birds looking at her, and a duck with like a twisted look on his face, and it's going to be a lot of feathers. It's going to be a feathery experience. Oh, they're cute. They're cute. Oh yeah, definitely. It's 2:38 p.m. in Hawaii, by the way. Water storage. They can store up to 40% of their body weight in the bladder as a water reserve, allowing them to survive for over a year without a drink. Whoa, these tortoises got some resilience. Burrowing lifestyle. To escape the extreme desert heat and cold, they spend roughly 95% of their lives underground in tunnels that can reach 30 feet in length. Diet. These herbivores primarily eat native wildflowers, grasses, and cacti, getting much of their hydration from plants they consume. Longevity. Desert tortoises are extremely long-lived, typically reaching 50 to 80 years in the wild, though some have been known to live over 100 years. Coffee time. All right, let's see what these things look like. I've seen those things before. Yeah, some of them look cute. Yeah, they're interesting. But they do look kind of like mice or rats. They do. I could see a resemblance to them. Loki says they are protected here. You have to apply to have one as a pet and have a will with custody plan. Oh, okay. Scared. Okay. Thanks for the information, Moki. And oh, that's hilarious, Missy. Where's my rat trap? All right. All right. Reproduction. They take 13 to 20 years to reach sexual maturity. Interestingly, sex of the hatchlings is determined by the temperature of the nest during incubation. Defense. When threatened, their first instinct is to react with their thick dome shells. However, they may also void their bladder when frightened, which can be fatal if they cannot quickly replenish their water supply. So that's some fun facts about the tortoise, the desert tortoise. Moki said, no lie, those tortoises live a long time. They also tear up your yard digging. They're kind of like raccoons. Gotcha. Wow. Black squirrels here, the raccoons do damage. Yeah, that is true. Moki says, we don't have squirrels here, but we do have chipmunks and prairie dogs. Oh, interesting. Oh, groundhog. That's cool. I like those animals. Okay, so Moki says they have tarantulas. Oh, those are very interesting. Well, they're actually very scary, but they're interesting. Yeah. Oh, Falcon, tell us about some of the ghosts. I'm interested to hear about that. Scared. Oh, it stinks. Oh, yeah. She definitely needs to do that. Yeah. Yes, and over in Nevada they have aliens. They have extraterrestrials. That's true. They have quite a few of them. Oh, Falcon's not allowed to tell. Oh, scared. Scared. Well, I'm gonna have to do some research on the Tasmanian ghosts of my own because it seems to be, but the exclusive information seems to be top secret for now. Right. So the black squirrel is a distinct species. They are a melanistic color variant of the eastern gray squirrel, or the fox squirrel. The striking appearance is caused by genetic mutation. Overproduces dark pigment, a trait likely inherited from breeding with the fox squirrels. Falcon, I definitely think that humans, especially with these trials that we've seen, I agree with you. Yeah, Moki is an alien. That is true. And Lori said, scared. Yep. Yeah, Moki's one of the aliens from there. These squirrels make up about 1 in 10,000 of the general eastern gray population. Their coloring offers specific evolutionary perks. Cold tolerance. That is true. It is in her name. That is true. Moki says she's a short white. Yes, that's the alien species she is. A short white. Yes. Hello, Mary Toodles. All right. Cold tolerance. Their black fur absorbs and retains significantly more heat, reducing heat loss by 18% freezing temperatures. Camouflage. In dense, old-growth forests with dark canopies, their coloring provides better concealment from predators than typical gray coats. Oh, hello, Eugene. Gracious greetings to you, too. We're on Verdict Watch. Yeah, nano. Yeah. Somewhere, everyone is an alien. There you go. They are most common in North United States and southern Canada, particularly around the Great Lakes Basin. One love, one planet. Facts. Hello, Mermaid. Mermaid said, no ceasefire. This is bad news. Not happy about it. Oh, okay. Yeah. Thank you for the update, Mermaid. It's definitely a concerning situation. Indeed. Okay, Moki says instead, yes, there is 2-week conditional ceasefire. Oh, okay, Moki. I thought I saw something earlier about there was a ceasefire. Okay, thanks, chat. Where to find them? They are most commonly in northern United States and southern Canada, particularly around Great Lakes Basin. All right, Ontario, Michigan. These regions have the highest concentration of Ontario. 66% of the population is the black squirrels. Understood, Mermaid. Thank you for being here. Yes, Falcon. I like Monty Python. Yes. Black squirrel towns. Several locations have initially introduced and protected them. Those spots include Kent, Ohio, where they are universally mascot, and Marysville, Kansas, and Washington, D.C. A galaxy saw is indigenous. Wait, the galaxy song is ingenuous. Yes, absolutely. Very true. I got mixed up with words for a second, but I see what you mean. Yeah, Lori, the gas prices are very high, and they need to go down. Scared. United Kingdom, introduced to North America is early 20th century. They are now widespread in southeast England. Jet black. Offspring inherit two copies of their mutant pigment gene. Brownish black. Offspring inherit one mutant gene and one normal gray gene. Two typical gray squirrels cannot produce black baby because mutation is not part of their standard genetic makeup. Yes, the world is insane indeed. Absolutely. Mermaid said Lori went to the store and luckily just got a cord, found high prices, groceries ridiculous. Yeah, exactly, Falcon. There's the media definitely. Indeed, absolutely the media. Let's see. Get scared. Good point, Falcon. Oh, thank goodness for that, Lori. Arg. Yes, absolutely. Oh yeah, what will we do without the internet? Yeah, that's like definitely a society probably would collapse, but then again, maybe it may be well needed. Yeah, that's another good point, Falcon. Oh, Sailor Jerry's is good. Yes, I like that one too. Yeah, that's actually the one that I get, Falcon, is Sailor Jerry's. I like all the different rums, but that's the one that I seem primarily into. So, great minds think alike, as they say. Or Sally, Amen, Mermaid. Drink coffee and water. Yes. All right, Nevada is home to a diverse array of chipmunk species ranging from the widespread least chipmunk to the highly localized and vulnerable Palmer chipmunk. Because Nevada's landscape consists of isolated mountains ranges and separated by arid basins, these sky islands have allowed several distinct species to evolve and thrive specific elevations and forest types. Oh, Blackheart is something that I gotta try. All right. Definitely. All right. Add that to the list of rums to get. Facts. All right. The Palmer's chipmunk. The species is found only in spring mountains west of Las Vegas. It lives in high elevation, coniferous forest of 7,000 to 10,000 feet and is currently listed as vulnerable due to extremely limited range. Hermit chipmunk, a desert specialist that thrives in hotter, drier pinyon juniper woodlands in spring mountains. It occupies lower elevations compared to the Palmer's chipmunk. Cliff chipmunk. True to its name, its species almost always associates with cliffs, boulders, and rocky outcroppings. It is very agile climber, capable of scaling steep rock walls. He was sober for 10 weeks but relapsed. Lodgepole chipmunks, primarily found in the high Sierra Nevada mountains. In Nevada, its range is limited to the high elevation forests west of Lake Tahoe. Uinta chipmunk, also known as the hidden forest chipmunk. In some regions, it prefers high mountain, pine, and forest central and eastern Nevada. the diurnal lifestyle. Most Nevada chipmunks are active during the day, spending the time of foraging for seeds, fruits, and insects. Catching hibernation. The use of check pouches to carry food underground stashes while they don't always undergo deep, continuous hibernation enter a state of torpor during the cold winter months, waking up periodically to snack on their caches. Identification. You can tell the chipmunks apart from small squirrels like golden mantled ground squirrel, distinct stripes on their face. A 50G pouch of tobacco here is $130. Whoa. 50 grams. Whoa. That's a lot. Ecosystems. By storing seeds and nuts that they occasionally forget to lose, chipmunks are vital for forest regeneration and seed dispersal. Oh, the government tax. Yep. Murray said, I'm so tired of the high taxes, outstanding payments, and to do things, everything is a payment. When you get out, like if you do something, you gotta pay a couple of times parking, get in, sit down, eat. Yeah. They say try 6 meetings, and if not sure, try 6 more. Different meetings have different feel. I had find ones felt okay. Sponsor can be so supportive. Yes, Falcon. It's definitely survival. Exactly. Yeah, yeah. Just at one time it was probably a couple of cents or a dollar. Oh, I saw a short of somebody from the '80s, and they're going into a gas station, and this dude had $1. Bro bought chips, a couple of bags of chips, and a drink for $1. It was like, bro was like in a time machine or something, because it's like the way he was acting was kind of like how people act now, but like in a like the slangs and stuff. But the dude like had $1 and he was able to buy so much stuff. But now it costs like $10 to get a couple bags of chips and a drink from a gas station. So definitely the inflation thing has gone through the roof over the decades. It's quite ridiculous. Amen, Lori. That's very nice of you to say. Amen. Alrighty. Nevada chipmunk photography spots. The Spring Mountains near Las Vegas are primary destinations for capturing rare species like the Palomar's chipmunk. McWilliams Campground, Spring Mountains, located in the Highway 156, is one of the most reliable spots for the Palmer's chipmunk. They are often bold around campsites, making them easier to photograph, and then in the deep brush. Deer Creek Picnic Area, Highway 158. Look across the rocky scree slope opposite of the entrance for the Panamint chipmunk. Be prepared with a telephoto lens, as the species is notably more skittish than the Palmers. Hidden Forest, a unique high elevation spot, fine population of clipped chipmunks living in Ponderosa pines rather than their typical pinyon juniper zones. Lake Tahoe, along the flume trail and high elevation areas near the incline village, you can find lodge-pole chipmunks and shadow chipmunks. Yeah, definitely that would help, in my opinion. Mermaid, definitely. Maria Island National Park, a vehicle-free sanctuary where wombats, pelamons, no, melons, Tasmanian devils are common, especially at dusk. So that's a Tasmanian wildlife location. Narran Tapu National Park, known as the Surgati, Tasmania, is coastal grasslands and are perfect for photographers. Large number of kangaroos and wombats open alike. Hello, Saw Girl. Welcome back. Oh, you have to do the chores. Okay. Yes, you're back in time. Yes. It's 3:13 p.m. in Hawaii, and at 3:45 we're going to be they're allegedly going to go home for the day if they don't come up with a verdict right now. Maria Island National Park, a vehicle-free sanctuary where wombats, petamelons, and Tasmanian devils are common, especially at dusk. And the national at Nor National Park, known as their Serengeti of Tasmania, is coastal grasslands perfect for photographing large numbers of kangaroos, wombats in open light. Wait, why did they add time to the verdict clock? No fair, stomp split. Right, exactly. And absolutely, Saw Girl. Thank you for your thoughts on this. Very true. Oh, it's just the clock is keep on ticking, and it's just more and more time is passing by. I think that's what Lori meant. Yeah, and let's see this. Oh yeah, Saw Girl. Yeah, uh, I can understand that. Yeah, silly goose. It's counting. It's counting up. Yes. And Miss C says the advice would be to get another habit. Right. Oh, I've not really. No, I've not taken a break. I've been here the whole time. Yeah, I've been here the entire time talking, running my mouth. Amen, Falcon. Absolutely. Thank you. That was a motorcycle going down the street. Oh, Saw Girl, thank you for the feedback. I'm glad that y'all like this community and like the streaming group and all. I appreciate the feedback. Thank you very much. And shout out to all of chat. They help make the show the way it is. No, you drink so much hot tea. Hilarious. Now, for the record, I was talking earlier to let's see, let's see, list. That is very refreshing, Falcon. I love tea. Definitely a type of tea to add to the list of teas to drink. Definitely saw growth. That is too much. Absolutely. Oh yeah, yeah. It would definitely do that to you. All right. Oh, Lori, excellent choice. Oh, I like Sleepy Time Tea also. That's very good. So earlier I was talking about the Five Nights at Freddy games, and I'm just going to list the different games that exist because I talked about what the games are about. I'm going to list about what the games, like what the names of them are. Five Nights at Freddy 2014, the original game of Rundown Pizzeria. Five Nights at Freddy's 2 2014, a prequel featuring a toy version of the characters and no doors. Oh, Mermaid. That it will help that definitely. And I like iced tea and hot tea. I like both. I do like coffee too. But coffee's nice as well. I've had different coffees from around the world. So yeah, coffee's good. And but anyway, tea. Yeah, iced tea is nice, and I like putting lemon in tea. Lemon in tea is delish. You go through hot tea phases. I like hot tea and I like iced tea. I've also made mint tea. Oh, Lori said I keep calling it Fast Nights at Freddy. Yeah, that's a good one. Orange spice tea is good. Yes. Lori said I brought some wild bong implants to garden, and now honeybees love it. Yes, definitely. Definitely. Bogmans. Bogman. I've not had that before. Five Nights at Freddy 3, 2015. September, set 30 years after the horror attack, featuring the Springtrap. Five Nights at Freddy's 2015 focus on nightmare animatronics in bedroom settings. Five Nights at Freddy's sister location. 2016. Moves underground facility with Funtime animatronics. Freddy Fazbear's Pizzeria Simulator. 2017. A mix of business sim and traditional survival horror. Yes, Falcon. Yes, yes. I've seen that before. I like those horror movies. Definitely. Five Nights at Freddy's Help Wanted 2019 VR non VR collection of reimagined classic levels and new lore. Five Nights at Freddy's Security Breach 2021. The first large scale free roam game set in Mega Pizzaplex. Five Nights at Freddy's Help Wanted 2 2023. A sequel of VR experience with new minigames. Love everything about the FNAF. Purse is top notch and have big fuzzy fur. Oh, very nice, mermaid. Very nice. FNAF World 2016. An RPG featuring characters from series of non-horror Ultimate Custom Nights 2018 mashup where you can customize 50 different animatronics. Oh, that cookie jam. Oh, she thought that was a drink. Oh, good job, Lori. Good job. Compared to 13 billion years the universe has existed, you ain't that old. Oh, very good outlook of Falcon. Very positive. I like that view. Jigsaw puzzle. Five Nights at Freddy's special delivery mobile game. Security Breach. Ruin a free DLC expansion for Security Breach. A darker, more decayed setting. Five Nights at Freddy Into the Pit 2024. 2D retro style adventure based on Fazbear Fright's book. It's honestly dark because the story of F and AF is a father opened a Chuck E. Cheese, ended his kid's life, and their souls haunted the Chuck E. Cheese animatronics. Yeah, exactly. It was super hard. Falcon, that can it depends on which movie or which types of. Oh, Saw Girl. That's awesome. That's awesome. Yes, Falcon, they can do that. That is possible. Definitely. But not all of them do that, but some of them can. That's true. Okay, so movement. We got movement. Okay. Let's see what's going on here. Well, maybe they're probably going home for the day. I guess. Now it's a black screen. Oh, well, that's simple. Oh, okay. They just ended it. Okay, it is. It looks like they sent the jury home for. Okay, chat, everybody. They have sent the jury home for the day. And there you go. That's it. They'll be coming back tomorrow. Oh, yes, Hilarious Mermaid. It is 3:38 p.m. in Hawaii. Yes, the arrival. It's a time that the jury's been sent home for the day. And tomorrow we are. I'm not ending it right now, but like tomorrow we will see if they come back with a verdict. Okay. That is it. Yep. All right. Yes, Falcon. There is so much we don't know. Yeah, that is true. All right. So, did any of you hear about the offset report being shot shortly after Cardi B said her money was stolen and threatened to end whoever did it. Yes, I remember hearing about that last year, if I'm remember that correctly. Oh, Lori said, Yeoman was scary. I watch movies I shouldn't have young, but own fault parents didn't know. Yeah. Okay, good night, Miss C. Thank you for coming. All right, so the poll for today, 78% said yes, guilty, and 22% said no. If you think the defendant is guilty, those are the votes. Sawgirl says, well, Johnny Depp did a pretty good job in Sleepy Hollow, and I loved Christopher Walken in Headless Horseman. Oh, that movie was excellent. That movie was absolutely excellent. I loved how they did the aesthetic of the different types of gothic scenery and the darkness, and the acting and all was brilliant. Oh, Falcon. If it allowed me to do, I could see if it can let me do that, but it only has a yes or no thing. If it had the other option, I would do it, but I have to check to see if I could do that. Mermaid said, Alien, there was a new incident where Offset was shot and lived, and he was shot by another rapper. Okay. Well, let's see what that's about. Rapper Offset is currently stable condition after being shot outside a casino in Florida on April 6, 2026. Over 10 grand. Wow. The incident occurred just after 7 p.m. in the Valet area in Seminole Hard Rock Hotel and Casino, Hollywood, Florida. Exposed person for the rapper, whose legal name is Carrie Kendrell Cephas, confirmed he is being closely monitored at Memorial Regional Hospital with non-life-threatening injuries. Oh yeah, so the other night, there was a link Moki was showing me of this alleged real mermaid that was found, and some of these island people are being a little bit harsh with it. That's what she's referring to, and people think it could have been AI or could be real. We don't really know. But yeah, that's the mermaid we're referring to. But shout out to our Pools mermaid, our lovely Pools mermaid, and chat is awesome. Definitely. The incident occurred in just after 7 p.m. Yeah, I read that. Okay. Shooting origin. Police state the shooting began with a fight or affray of Valet area. Subject's arrest. Rapper Little TJ was arrested Monday night and charged with disorderly conduct and operating a vehicle without a valid license. He was taken into custody in connection with the incident. His attorney stated he was not involved in the actual shooting. Yeah, I saw a girl scared. Or he said, I love the restaurant scene in Splash where Daryl Hannah just bites right through the lobster shell. Right. Investigation. A second person was detained and questioned by and released without charges. Authorities are still working to identify other individuals involved. Sawgirl said, okay, have to have dinner or calling me for dinner, but I will see you tonight in the garden party. Love y'all. Bye bye. Okay. Sawgirl, peace. See you in the garden later. He shot the bubbles. He wants something. All right. So okay, that's information on the rapper that was shot. Oh yeah, there's a lot of haters that are stupid. You know, I think that's cringe. In Falcon, I think that life is a test, and what we could also do to help others. In my opinion. Mermaids are actually badass. Yes. Yes. The mermaids are badass. That's true. And shout out to the mermaids. Well, thank you, Mermaid, for telling me about the incident with the rapper. I think it's wrong for him to go hate on him for no reason. Mermaid said, breaking news, just a few hours into ceasefire, Iran is firing missiles into Israel. Oh, okay, Mermaid. Thank you for the update. Oh, Lori said, I don't know anything about rappers except Eminem, such a white girl. Yeah, Eminem's cool. Yeah. He makes lots of cool tracks. Let's see what Bubbles wants. I'll be back in a moment. Back in a moment. It's devastating to make what the F are we waiting for want it done. Those poor kids praying for little kids. Can't take it anymore. Known a lot of Iranian folks online. They're screaming for help. Okay. And Falcon said there was a man who had a near death experience when he got to the angels. He was asked what he had learned about love. All children deserve a sacred life. Yeah, definitely. Absolutely. Or I said, I don't know why this just popped into my head, but one of my fave movie scenes is from Hook. That's a good movie. When the old guy Toodles opened up the door, yells, "It's snowing," and slams the door on Robin Williams and his family. I remember that movie. It's very good. I enjoy it. Definitely. They do, and the things I've heard happen to children makes me fall over and cry. Definitely Mermaid. Absolutely. Yeah, Mermaid, and in God's greatest planner and His timing, all things will come to pass as they're supposed to happen. Like everything is already written as it's going to happen, so to speak. So like He has it already planned out, and I believe He will take care of everything that needs to be taken care of. That is true, Falcon. That demons do rule the world, and they cause great deception and trickery to people. So yeah, demons do, and we are in the fallen world, so we're going to see things that are messed up. Absolutely. And I admire your passion, Mermaid, and your desire for justice for all people. Right. And Mermaid said, Falcon, yes, and they say it was very real and truth. It says that the Bible, Satan rules the world. Yep. Absolutely. Yes, I agree. Love is the way. Yes, Lori says, but the light will dispel the darkness. We must keep the candle lit. Amen. Yes. My heart aches when I hear about kids always watching stuff about it, and some I cannot watch. Try to imagine, can never imagine it. Let them go, realizing that all children are 13. Yeah, love will always win over evil. That is true. That is true. Because hate only destroys, but love would be the cure to a lot of the problems that we see. Yeah. Oh yeah, Mermaid. There's definitely gonna be lots of missiles gonna be flying into Israel. You know, that's gonna be happening for a while now. Yeah, and definitely with the actions were taken that people everyone did what they on both sides have done what they have done, whatever that was, and now we're in the situation we're in, and yeah, we will see that. Hope there was a ceasefire, which I would think that at some point, if there could be some sort of ending to this, would be good, because it's not good for the people there that are getting attacked. So whatever needs to be done to stop these type of attacks on the people there would be good. But yeah, it is Wild Mermaid. We're in some crazy times, and there's not enough love in this world, So remember, Christ has overcome the world, and take heart in that. Definitely. Definitely on social media, there's lots of videos of what's going on. Also, in different parts of social media. So I think the internet has definitely shown all kinds of things happening. That the mainstream media would not show. Oh yeah, Mermaid, and we're here for you, and we are glad to be here. And thank you, Mermaid, for saying what you're thinking, venting. I'll check, Lori. I'll check. Let's see. All right. As of today, April 7, 2026, there is active, albeit precautious, 2-week provisional ceasefire involving Israel and Iran. This pause was brokered by Pakistan and announced by U.S. President Trump. Okay, so there's a ceasefire. Now, Mermaid's claiming, I'm not saying she's making it up, but I'm saying Mermaid's saying that there are missiles being fired by Iran. Oh, I got you, Mermaid. Okay. I see the ceasefire was like a trick. Okay. I see what you're saying. Yes, Falcon, it's definitely not good for mental health. I agree. Watching the garden and the different things to talk about is much better for the mind. So this is the news what Mermaid's talking about. All right, here we go. Yes, missiles and rockets are currently being launched into Israel as of today, April 7, 2026, despite the announcement of a 2-week provisional ceasefire. Multiple barrages have occurred throughout the day. Iranian missile barrages. Just hours after the ceasefire was announced, the IDF identified missiles launched from Iran toward Israeli territory. Sirens have sounded across southern, central, and northern Israel, including Tel Aviv, Haifa, Jerusalem, and Beer Sheva. Oh, that's cool, Falcon. That's cool. Definitely, the Iranian people are cool. And Murray said, yes, Iran is firing a bunch of in Israel about 1 to 2 a.m. there. Super good not to watch the news. Yeah, and I would like the Iranian people to be free and with a nice government. As I said, I think that like religiously they could practice for whatever religion they want to over there in Iran, but it's good for their government to be a good government for its people. Right. But yeah, that goes for all the Middle Eastern countries though, like just every single one of them. But yeah, I don't think any government's perfect, but yeah, there seems to be some issues going on. Or he said, I can't get out of my mind that the region at war, Iran, Iraq, Syria, Israel, is some of our most ancient human history. Yes, Lori, and it's very historical, going back from centuries ago, and it's very upsetting to see them all at war. And I would like there to be a way where there could be peace. Definitely. Lori says, I know oil is a big driver, but I think there's more to it, old and deep. Lori, I do agree with you that definitely they want more oil and stuff like that. Yeah, I do think that's a factor because definitely money is a factor in it. And Iranian missile barrages have just hours left ceasefire, and was announced I read that cluster unitons. Iran is reportedly using ballistic missiles equipped with cluster unitons, which have impacted dozens of sites across central Israel. And Lori's not doing her chores. Mermaid said, also bothers me because they could just destroy it or have it probably. Hezbollah attacks. The North Hezbollah has launched over 24 waves of attacks today alone. Approximately 10 rockets hit the city of Nahariya, injuring civilians and damaging homes. Okay. Oh yeah, ancient buildings. Yeah, the history is definitely interesting. And Falcon, it would be nice if there was more, peace, like more love in the world and stuff like that. I definitely think that would help everybody, like what you said. And all opinions are welcome about this, by the way. Thank you, everybody, and everybody's making some good points. And the Houthi drone missile strikes. Houthi forces from Yemen have also claimed responsibility for drone and missile strikes targeting areas of Eilat and Ben Gurion Airport. Casualties: missiles impact the southern town of Tel Sheva, have resulted in injuries to civilians, including 2 teenagers. A previous strike in Haifa, April 6, killed 4 people. Significant damage has been reported in Ramat Gan, where cluster missile hit the residing buildings. Other impacts the Benai Barak and various suburbs in Tel Aviv. All right, so that's the information about what's going on in Israel right now. They're firing more rockets into it. Oh, she decided to leave her chores because we were way too fun. Scares me and heard more about tunnels and Epstein stories, like they were tortured underground and there's no way to leave. Falcon said, Israel just wants more land. Okay. Thank you for your perspective. And let's see what else is going on here. Yeah, Epstein is really messed up and all that, what's going on. And I think that definitely Epstein's a big cover up, and any countries that were involved with him or officials that were involved in him are very suspicious. And I think these billionaires are so rich they're able to censor the information that was going on. You know, that's why there's so much redacted information. Yeah, Disney. Yeah, and MK Ultra. Disney and MK Ultra were allegedly involved with each other. Yeah. Oh, thank you, Lori. Thank you. And Lori says, Alien, I want to say I'm proud of you for giving your all into the channel and to us. I know you've been going through it hard. Appreciate you very much. Oh, thank you. Thank you. Yes, Falcon, it's like Stranger Things. Yes, definitely. And remember, that's so cringe. She says, I heard it take kids down there, and if they're injured, that's why you never see them injured in a park. Yeah, yeah. It's like Stranger Things, and it's definitely like these monsters they talk about definitely are real, but they're in human form. I think there's also, they act like reptilians in a way, too. Yeah, yeah, very good point, Falcon. Okay. And yeah, it's definitely like a labyrinth a lot of times with these things. You know, there's a labyrinth maze of what's going on. And I think that it's good that we can see the truth and solve the puzzle, but it seems kind of bizarre about what else can be, talked about in it. Definitely. Because, who are the people behind it? Why are these people going missing? It's like it's all linked to one click. Oh, Lori, that would be delicious. That would be delicious. I'd like that. And last night on the Garden Live, we had a good crowd. By the way, we had a very good crowd, and a lot of cool topics. And I love my overseas spaceship crew. It's nice to have. Oh, you used to love the crackling. Yes. Yeah, and definitely like there's different ambient sound effects. Oh, understood. Poor piggies. Understood, Falcon. Thank you. And the the thing with these yes, need to finish Garden Live. And shout out to Falcon. He's with me on the Garden Lives, and he's an excellent mod. That does great. I like his take on things, and very good crew member. And Tasmania is so cool. Like it's very interesting to learn about. And yes, the Garden Live was very good. I was pretty. We went for quite a while, into the night, into the morning. Yeah, it was nice. Big audience. Different conspiracy theories were talked about. So yeah. So with these different sound effects that people will have, they'll do this ambient, and sometimes they'll have like fire crackling sound effects. And that is very cool to have. By like a campfire or something that is, it's like you kind of like relax or think about things with the sound effects in the background. So I do like the ambient sound effects that they have. In Boston, there's this like medieval tavern type restaurant that's based on the colonial era, and it'll be really nice. It's just staged like it's from a long time ago. So I think those types of places are so cool. All right, looks like Bubbles is calling me again. So let's see what's going on here. Be right back. I've returned. All right, so I'm addicted to Fire Stream videos along with the Creeks of the Ocean Rain. Bubbles is calling. Did y'all know he can actually speak human? Yes, yes, he can speak human. That's true. Okay, and Falcon, thank you for modding the Garden Lives. They're usually when I'm asleep. Yes, yes, that is true. Mermaid said, Lori, I saw a new gadget I might get where you can put a camera on a collar and you can call it and talk through it. I'm going to get one for my dog. Oh, yeah, absolutely. Absolutely. They can be very wild. Let's see. Gadget. Yeah, Mermaid, they could definitely be crazy. There are some trolls, and there's also some cool people too at the same time. But definitely, the trolls are really crazy. And let's see. A friend of mine put one on the cameras on her cat and recorded her catching a bird. My friend was pissed. Right said, Lori, haha, I need one. Let my dog out and he doesn't come back. I was like, you need me to call you and chew out. Hilarious. And Mermaid said, I like the garden lives. They're fun, but yeah, I'm there messing up those trolls. Oh, Mermaid, y'all have you have a lot of fun with those trolls. Yeah, you definitely put them in their place very well. They're fun to mess up. And Lori said, the trolls bless their little hearts. Yep, exactly. Yeah. Yeah. I hear your bubbles. You came back. Oh yeah, understood, Mermaid. Yes. Yes. Yes, I thank you, Mermaid, for modding those lines. Definitely. Shout out to Mary Toodles. Mounting accessory used primarily for large telephoto lenses. It wraps around the barrel of the lens to provide an attachment point for a tripod or monopod rather than using mounting point on the camera body. Yeah, there's Brig and Sunny. Those two are very good too. I love when they ask Alien and he says he's on Earth somewhere. Yeah. Yeah. Lori said hi to Mary. Yeah, Mary said hi back. Mary said, of course, and they get kicked out because they just want to be a streamer. They want to be streamers. They all have no actual YouTube. Yeah, exactly. They have like little, they have like nothing going on for them on their channel. Right, exactly. They want to feel like they're something, but they aren't. Oh yeah, Mermaid. Exactly. I know you're talking about. Yeah. Yeah. He's funny. A camera collar is a specialized mounting accessory used primarily with large telephoto lenses. It wraps around the barrel of a lens to provide an attachment point for a tripod or a monopod rather than using the mounting point on the camera body. You remember it's weird world, totally different on garden. Yeah. Those garden lives usually average up about 1,000 to nearly 3,000 sometimes. Not we have not hit 3,000 yet, but they either get to almost 3,000 or over 1,000. Yeah, so those are not hostile, you could say. Yeah, they're definitely thrilling, dude. Large lenses are often heavier and carry themselves. A collar shifts the mounting point at the system center of gravity, preventing the tripod from tripping and erasing steadier shots. Lori, that would be so cool to upload. Oh, thank you, Mermaid. Appreciate it. The seamless rotation. Most collars allow you to loosen a knob, rotate the camera between landscapes and portraits. And removing from the tripod. Yes, Claude may try to slay me, and he very well may succeed. It won't be. Yeah, he will definitely go try to take my hand off or something if he had that on him. Yeah, he would freak out, definitely. He would slay. He'll be the alien slayer. Specific collars, traditional collars designed for specific telephoto lenses like a Nikon 700 to 200 millimeters. Oh yeah, Lori, he is a cool cat. Claude's very popular, and he likes being on camera. Yeah, Lori, hilarious. Yeah, Claude as the Claude Slayer. Spider Pro lens, $65, designed for 700. Yeah, and the yen The Nikon RT1 tripod mount ring is $241. Is premium free rotating ring specific for Nikkor lenses. I agree. I think he was one as well. Tink. Silence Corner, a rotating collar for mirrorless cameras that maintain the center of gravity during rotation. And there's the Leiwa tripod collar, $30 specialized collar for macro lenses where stability is critical. All right, so something. By the way, I'm going to talk about fencing. Fencing has evolved from lethal system of military training and personal defense into a highly technical Olympic sport. Its roots trace back to over 3,000 years, with some of the earliest evidence of fencing, like maneuvers found in the ancient Egyptian tomb reliefs dating to roughly 1190 BC. Foil, 17th century France. Originally developed as a safe, lightweight practice weapon, the small sword, because early practice was done without a mask, target area was restricted to the torso, prevented dangerous facial injuries, the rule that remains in modern foil. In 19th century France, born as a reactionary, increasingly artificial, non-material rules, the épée amid simulate an actual duel to first blood, which is why the entire body is valid target. There is no right of the way rules. Or he said, the way we get horses used to the new thing is to rub hay and grain on the object, put it near them, and give them a treat like a carrot, apple, or grain. That's a good idea. Very interesting. After about a week, they associate the otherwise dreaded object with food, and they accept it, even look forward to it. Oh, very cool. Very cool. I did that to get a halter or a yearling and had never won one. I don't even know what that is. Interesting. Ah, okay. Oh, I know what that is. Yeah, thank you. I did that to get a halter on a yearling, and that had never won one. Oh, okay. Well, at some point, I believe there will be victory with it. I like that. That's how you get a horse associate with an object. Give them a treat, and they associate it with the dreaded object with food. Facts. All right, the saber derived from military cavalry sword. It is its early sporting forms. Fencers could hit anywhere, but target was eventually limited to above the waist to simulate the area a soldier would protect on horseback. I do not know about that, Lori. I, but that is an interesting thing to possibly ponder. Yeah, I don't know. He might become the alien slayer. We'll see. 15th century, 16th century. The Renaissance saw a rise of professional fencing masters in Italy and Spain. Schools like Anglo School of Arms began transitioning fencing from combat to an art of grace and strategy. 1880. The first formalized fencing competition was held in London. Great military tournament and assault at arms. 1896, fencing became one of the original sports and first modern Olympic Games in Athens. It is one of the only 5 sports to appear in every modern Olympiad. 1913, the International Fencing Federation was established at a standardized rule globally. All right. Let's see. All right. So let's see. While the horses share deep genetic history, the breeding intent are status. Okay. Breeding intent, selective nature. Primary difference lies with humans' environment design. Selective breeding. Indigenous breeds. Breeds like the Appaloosa and Chickasaw horse were created through purposeful human intervention. Indigenous nations selected specific traits like Nez Perce are prioritized endurance or distinct spotted patterns for camouflage and identity, while Chickasaw bred for explosive quarter-mile speed and agility. Natural selection. Feral regional strains. Breeds like the Mustang and Marsh Tacky were largely shaped by their environment, and Marsh Tacky, for instance, developed a narrow chest to help it cool down in humid Carolina swamps, and a unique ambling gait to navigate deep mud without getting stuck. The indigenous breeds consist of living legacy of the cultural partnership between tribes and horses that began earlier than many history books suggest. Feral breeds. Mustangs are legally classified as wild under the Wild Free Roaming Horses and Bureaus Act, though many Bureaus Act activates and advocates argue that they should be reclassified as native reintroduced wildlife rather than invasive species. Recent DNA studies show that while most of these horses have Spanish Iberian roots, isolation has created genetic islands of marsh tacky is now genetically distinct breed from the Florida Cracker, despite both starting from the same 16th century Spanish stock. Similarly, the Nakota horse includes unique influences from 19th century French Canada ranch horses found of the Western Mustang. Oh, that is cool. That is cool. I'm glad that y'all like that. Let's see. And yeah, I love the markings and colorings that they have on them. Like the Native American ones are so cool. All right. And let's see. Maury said, I was in the 4-H horse club for years and showed and gained like a whole bending for many years. My mom and I had so many good times with our horses. Oh yeah, I'm sure those are very fond memories that it's good that you got to experience that. Definitely. So this is how the Native Americans acquired horses. They did it through combination of reintroduction by Spanish explorers, the Pueblo Revolt of 1680, and vast intertribal trade networks. Horses originally evolved from North America. Horses originally evolved in North America. They had been extinct on continent for thousands of years until the 15th century. Spanish reintroduction. Christopher Columbus brought horses to the Caribbean in 1493. Later, Hernan Cortez landed in Mexico 1519 with 16 horses, which eventually grew into large herds as the Spanish moved north into what is now the American Southwest. The Pueblo Revolt, 1680 rather. This was a major turning point. Indigenous Pueblo peoples in modern-day New Mexico successfully drove out Spanish colonizers who abandoned over 1,500 horses. These horses were then traded in tribes. Horses moved rapidly across the continent via established trade routes. By early 1700s, they had reached the Nez Perce, Blackfoot, and Northwest and Lakota northern plains, raiding tribes for horses. Interesting. Okay, let's see. Modern horse clubs. All right. Modern horse culture in American prehistoric. Modern horse clubs. These organizations focus on documentation, promotion, and preservation of horses with indigenous ancestry. So they have American Indian Horse Registry. Established in 1961, this registry collects data of horses of diverse indigenous ancestry, ranging from Mustangs to rare Choctaw and Cherokee strains. Appalasa Horse Club, founded in 1938, specifically to save spotted horse of the Nez Perce people. Today they govern international competition in everything from racing to dressage, using modern crossbreeds to improve spirit speed. Oh, that's very cool. Let's see this right here. Oh, let's see. The Surfs 4-H Oceanside is a notable coastal club where members participate in equine competing with categories in the study of horses. Let's see. Let's see this. That is very cool, Lori. That's very cool. Surfing Coastal Convention Clubs. Some clubs, the Golden Beach 4-H Surfers Club in Oregon, are partnerships between local university extension offices and Surfrider Foundation. Activities. Members engage in surfing, indoor boarding, and watching surf films. These clubs blend reaction with education on marine conservation, coastal stewardship, and water safety. Eligibility. Programs often serve youth in grades 4 to 12, sometimes allowing younger children to participate with a parent. In other areas, surf riders are similar names to Virginia Beach 4-H, and Wave Wanderers refers to Equine Focus Club. And we have that, so that's pretty cool. And the Oregon coast with the surfing stuff is nice too. Let's see. Surf riders on the Oregon coast primarily refers to the surf club. Lori said, I was the president for 2 years. I think it was Elder Scrolls Online. I have to check that out. Let's see. I may have Falcon. I have to look it up. Lori said, I was the president for 2 years. I think it was got to carrying a big American flag and ride my horse in a parade. I was so proud of my horse Frosty she wasn't scared of the flag. Oh, that's good, and that's cool that you were the president of it for some years. And big American flag ride and horse. Oh, what breed of horse was it, Lori? That's very cool. Let's see Elder Scrolls. Let's see what that is. I have MK Ultra. Yes. Okay, I haven't played this game, but I have it saved. Thank you. Frosty Flakes was the golden Pelomino when some white flakes on her rump. She wasn't registered, but so beautiful and cool. Oh, that is awesome. She was Alpuza, quarter horse, and Arabian. Oh, that's a very good mix. In Oregon, the Riders 4-H Club primarily refers to a unique surfing and marine coastal program. Golden Beach to similar youth. Let's see. Let's see. Where he said she liked my dad's pipe tobacco and could take a beer bottle in her mouth and tip it up and drink it. Oh, that is a tough horse right there. Very tough horse. But yeah, and a name also belongs to a group. You just read Alien. I don't know if my old club still is active. Diablo, okay. Oh, understood, Lori. Yes, and love that movie. Hildago. That is very cool, Tasman. I got your Falcon. Okay. Makes sense. Oh, you've ridden a camel before and a horse. Oh, a camel must be interesting to ride. Yeah, that's very cool. And you know the I rode a pony one time when I was a kid, so that was fun. Maybe a horse too. Also, Viggo Mortensen. Oh, okay, Lori, that's really cool. He was very good in Lord of the Rings, by the way, Lori. He was very good in Lord of the Rings. Oh, ouch. Uh, some beakies went past one, and the horse reared up, and I fell off. Yikes! And also, ouch. But got back up, and it was about 10. Wow, that must have been startling. Yeah, definitely that would scare a horse. Scared. But yeah, very great actor. Oh, very good attitude. It was more exhilarating. Yes, that's good because it exhilarating, and then you get back up on the horse, and nice positive attitude about it. All right. So, definitely horses and camels and all those types of very cool. There's some people ride elephants in different Asian countries, by the way. Okay, and now my some of my family had goats before, like a goat farm. Uh, those are cool farm animals, by the way. Where said I was bucked off when I was 10, wind knocked out of me. Thought I was dying. Oh, he used to break horses. Oh, very fascinating. She was bucked off when she was 10, wind knocked out of her. Thought I was dying. Right. Scared. I ride an elephant at Wildlife Safari here in Oregon. Lori, that's so cool. Rode an elephant before. It was like riding a rocking building. Ah, yeah. That is that is epic. It probably was like a constant Hannibal. Yes, it's probably like in a state of being like in an earthquake. So that is something cool to know that you were on one of those horses. Oh yeah, Hannibal. Yeah, I know you're talking about. Scared. That sounds like a cool place to meet, too, Lori, and a place to visit one day. You know, the cool animals that are there. Yeah, not Lecter, the general. Ah, okay. Because I'm thinking, I'm not too sure which one you meant, but yeah, Lecter, the general. Gotcha. All right, Lori said it's in Winston, Oregon. We had a biome there very similar to African savanna, except we get more rain in winter. Oh, cool, cool. I like that. When I was growing up, I used to play the Oregon Trail on the computer at school, and I definitely think the that was a fun game to play, and I like the idea of the survival in that type of wilderness. So Oregon's definitely uh, a a frontier terrain, indeed. Where it says it's pretty cool. You'll slowly drive through and see tigers, lions, antelope, and parts ostrich, lemur, bear. Oh, I like to see that. That's really cool. Oh, yeah, it sounds like a cool game. Yeah, you would like go on the terrain and get food. I played it on my DSi too, so it was on the original Max from the 2000, I mean from '98, and they brought more of them over time. They evolved the game. It's still available now. People could play. It's definitely advanced since then, but it was a very cool game to play on that computer. Definitely. Let's see about those Amazonian fish. Let's see. Lori said if we have pretty much every climate except tropical jungle, we do have temperate rainforest. That that is really cool. Oh, he loved his DSi. Okay, the fish is called the Candiarui, a small parasitic catfish from the Amazon basin, often called the vampire fish or uh, kiwi fish. While legend says it swims up a stream of waste into a human's body, the modern science has largely debunked this myth. Myth. For centuries, the travelers and locals have climbed the Candiru attracted to human waste following the scent into the body of a human, where it lodges itself with a sharp, backward pointing spines. Physics. It is physically impossible for a small fish to swim vertically up a falling stream due to basic fluid dynamics. Scientific findings. In 2001 study, the kangaroo hunt primarily by sight, not smell. When it tested, the fish showed no attraction to the human fluids or other chemical markers like ammonia. There's only one modern documented case from '97 in Manaus, Brazil, where a urologist claimed to remove a kangaroo from a man's body part. However, this case is highly controversial and widely believed to be a marine biologist to be a hoax. The size and consistency and intact spines. So it's likely a myth, but there's a alleged document case of it. Yes, amen. Oswald West State Park, Drift Creek Wilderness, Rainforest Reserve, inland locations. Temperate rainforest. Yeah, Lori, what's up? If there's 1% chance it's true, okay. Scared. Scared. Game over. Yeah, it's like if there's like 1% chance it's true, just like with the conspiracy theories. It's like they say it's like not true, but you know, then they say, but what if it really is true low key? It would be scared. Scared. That is true, Falcon. That is true. It could be true. I'm not going to take any. This is what I'm going to do, Lori. I'm not going to take any chances with that. Eugene says, I know you probably talked about it, but I keep seeing former government officials talking about aliens, UFOs. Newsmax just talked to an expert that claims it could be a fake invasion. Ah, you see, that's Project Bluebeam. The fake alien invasion. You see, I thank you for telling me about that. They know the truth and they talk about it sometimes, right? Like they know what's going on. But they're not going to really tell us only in just little pieces. in bits and pieces. Yeah, I like the temperate rainforest. They look pretty cool. All right. Thank you, Eugene, for that scoop. What's going on? Okay, and let's see here. Wait. All right, so as I said before, we're going to be doing the late night stream. I mean, the Garden Live later on tonight. And at this point, we're going to be ending it for the night, and we'll be continuing the coverage of the trial tomorrow, and I'll be doing the Garden Live a little bit later. Thank you, Lori and Falcon, Eugene, for this great conversation. All right. Appreciate it. And Eugene says, someone mentioned in the comments that the aliens gave us advanced technology for us, but obsolete to the aliens. Well, Eugene, it's not obsolete for the aliens. All of the different people on Earth can use it. And the aliens themselves, too. So, Eugene, I think that the aliens were it was from aliens, but it was also aliens benefit from it too. All right. So, thanks everybody, and thank you all for coming. And what's your take on? What's your take on Trump? I used to kind of like him, but now it sits me to tears. And so, what I think for the American right now, inflation is very high all over the place. Usually because of the 2020, there was lots of checks that were passed out in time, so it caused inflation all the way to this time period. I probably get more into it on the other live streams, Falcon, but I think I agree with you where there's things that I like that he does, and I may not agree with everything he does, but as I said, I usually have no problem with him. I understand over where Australia and other places like that are not having a good time from policies he has, but usually with America, he seems to be handling the country well, but then again, there's lots of inflation going on and different conflicts. So that's what I think. Well, I would like to see the inflation go down, and there could be a place, maybe the world can be a little more peace in it. But he seems to be doing things he has done things that are good for the country, for America. It may be affecting other countries negatively, though. Understand that. But he seems to trying to handle things in the United States pretty good. But I do know that, he may not do everything perfect and do things that are not right, technically. So, yeah, that's my take on him. But I would like to see inflation go down. And I think we all would agree on that. And thank you, Falcon, for your take about him. Because I understand a lot of people are not really happy with him right now in general. But yeah, those are my thoughts about him at the moment. But there's lots of complicated things going on in the world in general that's far beyond him. So we'll have to wait and see what happens, and hopefully everything could get situated and boiled down, because things are heating up right now everywhere. So those are my thoughts about him, and thank you, Falcon, for your question. And now officially, peace.